Court of sir.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ನಾನು ವಿಸಿದಲ್ಲಿ ಇದ್ದೀನಿ, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್.
ಸರಿ ಸರ್.
ಓಕೆ, ಆ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ನಾನೇ ಅಪೇರ್ ಆಗ್ತಿದ್ದೀನಿ, ಕಂಟೆಂಪ್ಟ್ ದಲ್ಲಿ ಕೆಲವು.
ಸೀರಿಯಲ್ ನಂಬರ್ ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 4, 4, 5, 6 ಕಂಟೆಂಪ್ಟ್ ಇದಾವಲ್ಲ, ಅದನ್ನ ನಾನು ಅಪೇರ್ ಆಗ್ತಿರ್ತೀನಿ.
ಸರಿ ಸರಿ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
One
For
matter,
posting fresh matter, my lord, Tuesday. my lord. Okay.
one matter vacating Tuesday, my lord. My lord, fresh writ appeal, my lord, kindly have it tomorrow.
Tomorrow, any urgency for tomorrow, Monday it can come.
Tomorrow, my lord, kindly.
No, any urgency for tomorrow.
On Monday, my lord, Monday. Okay.
Your Lordship, one MFA, Your Lordship, matter was referred to mediation. The parties have settled, Your Lordship. Your Lordship may kindly have it tomorrow for between husband and wife, Your Lordship.
Yes, tomorrow.
One regular first appeal, my lords, matter is settled, may taken upon Monday, my lords, for
Monday.
recording compromise.
Yes, Monday. Yes. Orders list.
Page wise adjournment, page number 4, serial number 15 to 20.
Lord, serial number 18. I appear for the respondent. Short accommodation.
Lord, in this case,
Serial number
Lordship had directed to produce the inward register. It may be taken in the custody of the court and any date may be given. This is the forced entry made in the inward registry.
The appellant files along with memo.
Along
The original record register.
inward register.
To inward register. Same is taken on record and registry right to keep it in safe custody. And present it on the next date of hearing. Release the matter on? When do you want? No,
Lord, next week, any date.
Next day.
Please.
31st.
Please. 18.
Page number 5, 6 for 21 to 27. 28 to 31. Page number 7, serial number 32 to 36. 8, 7 to 39. 9, 40 to 43. Non-compliance of office objection. Second time, serial number 1, Amaresh S. Rosa.
Your Lordship, submission, my lord. I am for the respondents. 13 employees are there, my lord. And the office objection was trivial in nature. Overruling that, my lord, a stay has been granted till next date of hearing. Then understanding, my lord, that we will be ready. Only on the last date of roster, my lord, that was moved by my friend. And it was heard and stay has been granted. And the litigants, they are retired employees, my lord. Since 30 years, they have been litigating. And my lord, I am ready for arguments.
Pass over later.
Please.
Today only half day. We'll just run through the list. If we have time, we'll take.
Oblige.
It's any date
Because, my
maybe
lord,
for next
30
week.
days, since 30 years, my lord, they have been litigating.
Let us.
So any next week, any date, minutes, I am ready. During the course of the day, I will comply the office objection also.
Now it is trivial, my lord, is for that reason, stay has been granted. And my friend has submitted the same thing, my lord, that it is trivial in nature of his objection. We are also not objecting for that.
Tuesday we'll have it.
Please.
30th, my lord.
30th.
The intra-court appeal issue is also involved in
Maintainability.
that. 30th, my lord.
30th.
Oblige.
Serial number 2, Hema L. Kulkarni.
Weeks.
Yes,
Kindly weeks accommodation, minutes.
week's time granted
Please.
for necessary compliance.
Much.
Praveen Kumar Raikote.
Lord, I pray for a week's accommodation, my lord.
Week's time granted to take necessary steps.
Please, my lord.
4, Ramachandra K.
Lord, in this matter, my lord, third respondent already complied, my lord. Last occasion, day before yesterday matter, my lord. This is
Yes, learned counsel for the complainant.
third respondent, my lord.
submits that there has been compliance. And no cause survives for continuance of proceedings. In light of such statement made, submission made by counsel for the complaint, proceedings are dropped. AGA submits that compliance is complete, mail agreement, that there has been compliance. Yes.
GA, my lord.
GA, sorry.
Sorry, sorry, my lord, sorry. I'm sorry.
5, Deepak V. Bharat.
Yes.
My lord, we
In this matter, first respondent has to comply.
compliance memo is already filed, my lord. Thereafter, the complaint filed memo, my lord, by seeking that, in initial, my lord, they are,
What is the direction?
my lord.
Incorporate name in the Khata.
Khata.
Ah,
As per their representation, my lord, Khata is issued, my lord. That was placed before this honorable court along with memo, my lord.
hmm.
ಈಗ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ 13 ಖಾತಾಸ್ ಇದೆ ಅದನ್ನ ಎಲ್ಲಾನು ಕೊಡ್ಬೇಕು ಅಂತ. If they are provided the documents of that property, detailed document portal will ready to provide the khata.
I have filed memo, my lord, along with the application and details. my lord.
Correct. Now they are only saying that technically the contempt is insofar as in one case.
No, representation page 19 may kindly be seen.
Representation.
Page 19.
Nineteen of the contempt petition.
Yes, ma'am.
On 2/4/2024, my lord. We
Just
are
one minute.
pleased.
My lords, in this
Petition Sankhya
Yes, ma'am.
20449.
2413 to 2449. no. These are the plots. my lord, in that, my lord, only one plot they have.
Just one minute. It says only 2449. Where do you get this continuous number?
My lord, here, my lord, first initially 20-413. ಹಳೆದು.
ಹಳೆದು. ಹೊಸದು 2449.
My lord, may I produce a 6/1/2025 I have produced a memo. My lord, same survey number. In that, my lord, already there is 14 sites are there. In same survey number.
Mr. Deepak, now the only point is your representation is with respect to one side. 20/449. Ashte, insofar as others they have offered, we'll record it.
We are issued an endorsement, my lord, by saying that to produce all the documents, whatever required to issue an khata,
Contempt baralla. Maybe in the writ we would have done.
if they are submitted
My-
along with all the title
my
documents,
only- my-
authority will proceed in accordance with law, my lord.
My only submission. ಇಲ್ಲ ಒಂದು ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲ one they have issued, my lord. Other same with the same document I have made
Correct,
application.
but it can't be correct because the direction is only for 2449. But we will record their statement that they will consider that.
Yes, let there may be recording.
My lord, my respectful submission.
In
my lord.
accordance with
Yeah, in accordance with law.
Yeah, that's
Please.
the direction of the learned single judge was to incorporate name in the khata as regards the legal representatives of deceased Gajendra with respect to property in his name, isn't it?
Yes.
Huh.
No, not in his name. His legal representative. He is no more. No.
Correct.
Yes.
Legal representatives of Gajendra. With respect to property in his name. The respondents submit the same has been complied with and a copy is filed along with memo.
Memo.
Memo only which document?
Along with memo, my lord.
22/2/23 na?
I have filed a memo on 16/1/2000.
21/3/2024, I have filed a memo, my lord.
Correct. Your endorsement is this 22/2/2023. So where is that khata?
We are placed along with Khata I have filed.
For the office purpose. Has filed a memo dated 21/3/2024 and produced extract of the mutation register.
Please.
Extract of
Here.
mutation
E
register.
has to-
E
has
Khata.
Has produced the e-khata.
E Khata.
Insofar as the property in question. Full stop. In light of the same, the
I have filed a memo.
compliance of the order of the learned single judge is complete. Full stop. It is submitted that insofar as other properties belonging to deceased Gajendra, the same legal representatives have sought for e-khata, which is pending consideration before the authorities. Full stop. Learned counsel, though the said subject matter is beyond the scope of the contempt proceedings, learned counsel for the accused is to take note of such pending applications and dispose the same in accordance.
No,
with
no, my
law.
lord, that is also disposed, my lord. That is only my submission. On 2/4/2024, we are issued an endorsement by saying that if they are provided all the documents,
Learned counsel for the respondent submits. For the respondent. Learned counsel for the accused submits that the said request has also already been considered. An endorsement issued calling upon the complaints to produce additional records. And upon such production, they would look into and process the same in accordance with law.
my lord, it's not an additional record, original title record we are seeking.
Correct.
ಅಲ್ಲೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಮ್ಗೆ ಕೊಡ್ರಲ್ಲ ಒಂದ್ ಕೊಡೋದೇನೆ ಎಲ್ಲಾನು
Accordingly, proceedings are dropped.
Grateful.
Basava Kiran Jia,
Yes.
I'm for the week's accommodation minutes. I need to file affidavit on 30th.
At request
Your Lordship, any date after 7th, personal inconvenience or function,
after 7th,
after 7th, any date.
relist all.
twelfth. Till number 7, Sudhir Singh Bijapur,
Yes, for petitioner, my lordship. The case of the respondent number 1 is the appointed on compassionate bed as per the CAT, my lordship, Central Administrative Tribunal is annexure A is the impugned order, my lordship. At page number 35, my lordship, page number 35. Page number 35. To by him on 1/7/2016, and if he is otherwise eligible, to appoint to him the post of postman for the applicable vacancy year without disturbing the selected and appointed private respondent herein by creating a supervisory post of if any vacancy is available or executing a future vacancy. However, it is made clear that the applicant shall be entitled to all benefits from the date of appointment only. He is not eligible for the post as we created, my lordship. The postman as well as the other vacancies, my lord. He is not eligible as per our rules, 2008 and also 2010, my lordship.
No, on what
He's-
ground?
As per our, we consider application as per our rules, we rejected in 3 times, my lordship. Our CRC, that is Central Recruitment Committee, is there. And before that committee, his application is rejected due to the shortage of eligibility criteria, my lordship.
Compared to other respondent, my lordship, I am the highest point, 53 points.
Correct.
Now
we'll-
question, my lordship, is my father died on 2016. And thereafter, immediately within 3 months, I filed an application in 2016. And my application was pending for a period of at least 4 to 5 years. And at the time of application, 2016, 10 rules were applicable for me. So as per 2010 rules, SSLC was the criteria. So when they processed my application, the new rule 2018 came. Only
Okay.
basis,
Now we'll hear it, huh? We'll hear it, we'll fix a date and then hear it. Undertake not to take any precipitative action. Instead of staying it, either we stay or you undertake not to take any precipitative action.
already there is a stay granted by my,
There's a stay.
there is already stay.
Okay, we'll hear it on some, next week, someday we'll have it. Okay.
Please.
Have the date code in order, note date code. We'll hear it because it requires some hearing.
Please.
Put it first week and, put it, note one, put it. Huh? 7th,
7th.
7th.
Much.
Release the matter on 7th.
Stay may be continued.
The model earlier grant is extended till the next day.
This matter, my lord, regarding Port Kharab.
That time, put it. The,
My lord, I could not get the
no,
specific
that's-
judgment, but there are three other judgments, my lord, which say,
one division bench also. no?
Yes.
I have one. thing.
yeah, pleasure.
No, but that LAC you should have produced. That Justice Sanjay Gowda, the MSA.
Yes.
LAC to show the survey number.
Yes.
But I think I got it. That MSA, no?
Yes.
Has become final. That's
Yes.
your ground.
Yes.
But you are limiting it to the, to that MFA order, isn't it?
Yes,
Huh?
the division bench order, my lord, I am.
Correct, you're limiting to that.
This is the MSA order, Sanjay Gowda just.
Adi there. Could you? No, I'm saying you're limiting to that amount. You're limiting to the amount of this Narendra Prasad.
Yes,
no,
yes, yes.
Arvind, that
yes,
order.
Yes, my lord.
Yeah?
12 lakhs,
You're
yes.
not pressing beyond that.
No, my lord. We are confined to, my lord,
Yes.
this amount awarded under
See,
12 lakhs 70.
but you saw that remand order of the Supreme Court. That Supreme Court has sent back.
Yes.
All those 4 projects.
Yes,
So that's why
Yes.
I'm saying that we shouldn't dispose of MFAs just like some writ.
no, my lord, I think, my lord.
No, I'm saying in that other bank
Yes, yes.
matter. So now where are the claimants now?
Yes,
Claimants are at ground zero.
yes,
Isn't it?
yes,
So the thing of, okay, that whole project, same, all that logic doesn't hold.
yes, my lord, I followed, my lord, the judgments are there, but there is one more judgment after that remand, where they said that, my lord, you cannot reduce the compensation which you have paid to the others.
Correct.
So in that light only, we'll have to decide. Again, my lord, ultimately what has happened before the Supreme Court is, my lord, Supreme Court did not, my lord, could not afford, my lord, that time to, my lord, check that, my lord, whether they are similar or otherwise. Therefore, they were remanded back. And even, my lord, claimants also could not be present there and, my lord, make that, my lord.
That's why you have to.
Here, that exercise
that-
is, my lord, sent back to the
Correct.
court.
Here also, if we behave like, so I'm saying, when you're getting an order, if you have to get true relief, you have to ensure that we also put all the,
Obliged.
otherwise, what is the whole purpose of it? That time Monday I'm getting it.
Yes.
I asked them to post it on Monday.
Yes.
They are posting it before the single judge. How is that possible?
No, my lord, yes, that is not
It's-
possible.
No, whether it's settled or not is a different matter.
Yes.
Once the apex court has remanded it back, should be post before the,
For the,
because Supreme Court has said 3 months.
yes.
Forget how much time we.
But because in the Supreme Court judgment, my lord, they made an observation that so and so order is, matter is before the High Court. This may be heard along with those matters, my lord. Because of that observation, my lord, there were single judge matters as well. And, my lord, certain 4 or 5, my lord, division bench matters. All of them, my lord, went there.
Correct. So if the
That
division
was-
bench matters were heard, 4 or 5, easier to dispose,
Yeah.
then the single judge also could have
Right.
followed.
Right.
Let us, the appellant, who is the claimant, has called in question correctness of the order passed by the reference code in LAC 442 of 2011 on 13/8 to 2013. contending that the enhancement sought for having been turned down, the order of the reference court is liable to be set aside and the compensation awarded requires to be enhanced. The brief facts are that the petitioner's land in survey number 56 bar capital A small a measuring 10 acres of 10 acres of measuring 12 acres 5
Right.
guntas.
Yes.
Inclusive of 2 acres 5 guntas of Port Karab, situated at Adnur village of Chittapura Taluk, was notified for acquisition for formation of a tank near Vacha village. Full stop. The section 4.1 notification under the 1894 Act came to be passed on 4/8/2007, followed by final notification and fixing and award was passed by the land acquisition officer at rupees 34,500 per acre. We'll stop next. Next panel. The claimants not satisfied with the amount fixed in the award had filed a protest petition under section 18(1) of the Land Acquisition Act seeking for enhancement. Full stop. The reference upon a detailed consideration came to be disposed of, fixing the compensation at rupees 6,14,700 per acre insofar as 10 acres, and fixing rupees 2,000 per acre insofar as Port Karab land is concerned. Full stop. The reference court also granted other statutory benefits. The said order, full stop. The claimants had let in detailed evidence demonstrating the lands to be irrigated, that there were cultivation, that there was cultivation of banana crop, and that the Karab land was in effect being used for agriculture purpose. Full stop. The evidence of the revenue inspector. Who else?
The claimants and the revenue inspector. Revenue inspector, my lord, who was the revenue inspector for the region as on that day, as on the date of notification.
The evidence was let in of the claimant, and apart from the claimant, also
The horticulture
of the
officers, my lord.
of the revenue inspector at the relevant point of time as PW3.
Yes.
The evidence of Secretary APMC Chittapura as PW4. Evidence of Professor and Head of Department of Horticulture, University of Agriculture Sciences as PW6. Full stop. The case made, the reference court, though considered the evidence on record, has concluded by enhancing the compensation as referred to above. Full stop. It is the case of the appellants that the matter requires to be disposed of in terms of the order passed by the coordinate bench in MFA number cross objection.
MFA cross objection number 2000073.
MFA cross objection 2000073 of 2016. It is submitted that in case of the order passed in MFA crop 2000073 of 2016 relates to land of the same village under the same notification and relates to survey number 53/1/5 of consisting of 3 acres 1 gunta of irrigated land. Full stop. It is submitted that the said cross objection in the miscellaneous first appeal against an order of the reference court was filed in response to appeal filed by the state in MFA 201070 of 2014. Full stop. He submitted that the order passed by the reference court in the said which was the subject matter of adjudication in MFA 201070 of 2014 and MFA CROB 20073 of 2016 relates to LAC 443 of 2011, wherein the amount fixed by the reference court was 6,14,700, which is the same amount that has been fixed in the reference which is in challenge in the present proceedings. Full stop. Further submitted that as in the proceedings in MFA 201070 of 2014, read with the cross objection filed by the claimant, the state government had withdrawn MFA 201070 of 2014 and in light of the MFA CROB being allowed and fixing the compensation at rupees 12,70,000 per acre and such land being adjacent to the land of the claimant and relating to the same notification and same village. And the order in MFA CROB 20073 of 2016 having attained finality.
Yes, my lord.
Having attained finality, the present proceedings may be disposed of without entering into a reappreciation of evidence on the principle of parity. On the principle of parity. Full stop. Further submitted that the appellants are limiting their claim to the amount fixed in the aforesaid MFA at rupees 12,70,000 per acre. Full stop. Next, insofar as the fixation of compensation for Kharab land is concerned in the by the reference court in LAC 442 of 2011, it is pointed out that only 2,000 per acre has been fixed, which is erroneous, and the compensation ought to be fixed as per market value in light of the settled position that Kharab land, which in the present case is a Kharab land, is to be treated as property belonging to the owner. And if that were to be so, the appellants are entitled to market value as is for regular cultivable land. Full stop. This further submitted that detailed evidence had been let in of the revenue inspector to indicate that even the Kharab land has been cultivated.
Yes.
Full stop. Even otherwise, it is submitted that the Kharab land, a Kharab land, as is evidenced from the Akarband extract produced by the learned council for the state, being a public document, would indicate 2 acre 5 guntas to be a Kharab land, and if that were to be so, compensation is to be fixed. Insofar as Kharab lands also on the same ground as that of a normally cultivable land. You just show us afterwards in the evidence where you have said you are using it.
Yes.
When I'm dictating. Third, AGA is unable to controvert the assertions made and submits that the proceedings relied on by the appellant are one of record, and he would not make any further submission except by stating that the MFA and MFA 20073 of 2016 and order passed uh, in MFA, in MFA 201070 of 2014 and MFA CROB 20073 of 2016 are matters of record. Next, the question that calls for consideration is whether the appellant is entitled for enhancement and in terms of order passed in MFA crop 20073 of 2016, accordingly making out a case for interference in the order of the reference code passed in LAC number so and so. Next, the facts are not in dispute as narrated above. The extent of land of the claimant of 10 acres, of 12 acres, 5 guntas, including Port Karab of 2 acres, 5 guntas was notified for acquisition under section 4(1) for the purpose of forming a tank near Vacha village. Lands are situated at Hadnur village of Chittapura Taluk in survey number 56/A. Full stop. The land acquisition officer has fixed the compensation at 34,500. Though the claimant has let in detailed evidence relating to the nature of crops grown in the irrigated land, they have taken the stand that they would be limiting their claim insofar as the compensation awarded to adjacent land in MFA crop 20073 of 2016. In light of such stand taken, the requires to look into whether on the principle of parity, the claimant is entitled for enhancement to the extent as made in MFA cross objection 20073 of 2016. It must be seen that on a perusal of the order in MFA 20073 of 2016, it is clear that the subject matter of challenge was the compensation fixed in LAC 443 of 2011. Full stop. The LAC 443 of 2011. Do you have a copy of that LAC order by any chance? Which survey number that was?
That survey number is mentioned in paragraph 10. I'll try to get page number, internal page number 5, paragraph 10 of judgment in cross objection 20007.
Page?
Page number 5 of the judgment.
Paragraph 5.
Page number 5, paragraph 10. Second line.
Relates to land in survey number 53/1/5 of irrigated land, measuring 3 acres, 1 gunta of Hadnur village of Chittapura Taluk. It is not in dispute from a perusal of the order passed in MFA crop 20073 of 2016 that the subject matter of proceedings in the present case as well as in the aforesaid cross objection relates to land of the same village relating to the same section 4(1) notification and in which the land acquisition officer had passed an award for rupees 34,500 per acre as in the present case.
Yes, that would be important. It may have the categorization by the SLO and holding them under the same category, valuing them at the same amount. Shows that they are both similar.
Yes.
And the state having accepted that, they cannot now dispute.
Full stop. Next, it must be noticed that the order of the reference code in LAC 443 of 2011 had also enhanced the amount of compensation for irrigated land at rupees 6,14,700 per acre as in the present order of reference. Full stop. It would be relevant to notice that in the cross objection, the survey number was 53/1/5, whereas in the present case, the survey number of land, survey number is 56/A small a. Full stop. In both the cases, that is in the MFA cross objection as well as in the order of reference passed, which is subject matter in the present appeal, admittedly lands are irrigated lands. As rightly submitted by counsel for the appellant, the fact that the land acquisition officer had categorized the lands under an identical category and fixed compensation of 34,500 per acre would indicate that both the lands are identical in all aspects. Full stop. A perusal of the order in the MFA cross objection would reveal that MFA 201070 of 2014 challenging the enhancement made in LAC 443 of 2011 has been given up. Next, it is also to be noticed that the observation had made in the order in the cross objection at para 7 would indicate that the state had not filed an order, not filed an appeal against the order in MSA 200329 of 2022. Para 7 of the order in the cross objection reads as follows. Learned government advocate appearing for the state submitted that as per instructions, state has not filed any appeal challenging the order dated 27/7/2023 passed in MSA number 200329 of 2022. Perusal of the order in MSA 200239 of 2022 would indicate that the said MSA related to land relates to land in survey number 54/3 relates to survey number 54/3 of the same village. This court, while disposing of the MSA, has by a detailed consideration adopting the capitalization method and taking note of the banana crops raised, had fixed the rate of compensation at rupees 12,70,000 per acre. This would, the nature of the property that was the subject matter in the miscellaneous second appeals is further revealed on a perusal of the order passed in LAC 420 of 2011. It is perhaps in light of such stand that the state had given up their challenge in MFA number 201070 of 2014. Noticing that the court in the MFA crop had taken note of the compensation fixed in MSA 200329 of 2022, which had attained finality as is observed from a perusal of the observations made in para 7. The order in MFA crop has attained fixing compensation at 12,70,000 for neighboring survey number of 53/1/5 has attained finality. Accordingly, without entering into evidence relating to enhancement only on the basis of parity, taking note that the adjacent survey number of 53/1/5 has had the benefit of enhanced compensation of 12,70,000 per acre along with statutory benefits. The same may be extended in the present case as well insofar as land of 10 acres is concerned. Insofar as the Karab of 2 acres, 5 guntas is concerned, it must be noticed that this court, at the time of hearing of the appeal, had called upon the learned counsel appearing for the state to produce the Akar Band to verify as to the nature of Karab, land of the appellants. Learned GA has filed a memo before this court producing copy of the RTC as well as Akar Band. Clearly, the said document being a public document and having been produced by the state would indicate that the Karab of 2 acres, 5 guntas is a Karab. This court in the case of MFA 1945 of 2016, which was disposed of on 30th August 2024, had an occasion to consider as to whether Karab land was to be paid compensation. The division bench in MFA 1945 of 2016, after referring to the order passed in state of Karnataka versus represented by Principal Secretary, Revenue Department and another versus Istaq Ahmad Muhammad Sahib, ILR 2016, Karnataka 98, has specifically held at para 24 that Karab land is also to be paid compensation. And in fact, in the facts of the said case, the Karab land was paid compensation on par with regular cultivable land. Now, whether some amount has to be deducted towards conversion of Karab into cultivable land. There's one government order which says that this Karab land can be converted to cultivable land by following some procedure. That it becomes as much as so shall we make one some minor deduction?
10%.
10%.
My lord, may I make one sub?
Yes, sir.
The Port Kharab A lands always, my lord, they are of well farmhouse. And my lord, the area which is used for other than the agricultural purpose, they are A Kharab.
That's
B
correct.
Kharab are of stream, pathway, all that. Therefore, my to convert those lands to the agricultural land, only 10% expenses is very meager, my submission.
No,
So
conversion.
correct. Sometimes Kallu Marate ante irutte Karab. Sometimes. Now to make that land
ಬೇರೆ ಒಳ್ಳೆ ಮಣ್ಣು ತಂದು ಹಾಕಿದಾಗೆ ಅದು ಒಂದು ಕಲ್ಟಿವೇಬಲ್ ಲ್ಯಾಂಡ್ ಆಗುತ್ತೆ.
correct. Now their evidence, you go to that evidence.
Yes.
Quick. He has let in evidence to show even in that land they're cultivating, isn't it?
Yes.
Just point out.
Lord, PW1, Lord, second page, paragraph 5.
PW
1. Bhima Shankar. Second page of the chief, Lord, paragraph number 5. The deponent has developed the land so and spent. Paragraph 5, my lord, on the second page.
the deponent has developed land for horticulture purpose.
Pipeline and
obtaining land.
fertigation system and hence 2
And
acre
hence
5 guntas
2
of
acres,
so-and-so
5
was
guntas
also
land was also converted into cultivable land.
cultivable land. Lord, the evidence of Lord PW 3,
PW
3, my lord, Tulajappa. Paragraph 3, my lord,
PW 3,
Tulajappa.
Revenue Inspector.
Yes, ma'am. Paragraph 3, the claimant in so-and-so.
Paragraph
3, my lord,
ah,
about third line, guntas of
that the claimant has developed the land for horticulture purpose
by
by
leveling,
land leveling,
construction of fund
construction
so-and-so,
and
and hence
extent
20
of 12
was
acres, 1
irrigated
gunta
and under
was
cultivation.
irrigated under cultivation of horticulture crops.
So, my lord, that expense has already gone from my hand.
Yes.
My lord, technically, my lord, that deduction may also
Observe.
not come
Yes,
into.
we'll observe. The learned government advocate insofar as the Kharab land is concerned, no doubt concedes that a Kharab land belongs to the owner, but however would submit that Kharab land, compensation for Kharab land cannot be done by placing it on same, by treating it as cultivable land. As for the purpose of conversion of Kharab land into cultivable land, expenditure will have to be incurred, and accordingly, some deduction has to be made. Full stop. Full stop. It is the evidence of PW1 is specific insofar as conversion of Kharab land into cultivable land, as is noticed in the assertion at para 5 of the affidavit. Full stop. The specific assertion in para 5 is that the extent of 2 acres, 5 guntas of Port Kharab land has been converted to agricultural, to cultivable land. The said extract at para 5 of the affidavit reads as follows. Full stop. Further, the evidence of PW3, who is the retired revenue inspector and was the village accountant during the period of 2003-2005, is of relevance. In the affidavit, in view of oral evidence at para 3, it is specifically asserted that the entire extent of 12 acres, 1 guntas was irrigated land and under cultivation of horticulture crops. Full stop. However, it must be noticed that if the claimant were to convert the said land into cultivable land in terms of government order number so and so, a reasonable expenditure may have to be incurred. Full stop. Accordingly, it could be stated that a nominal deduction could be made insofar as Kharab land if the same is to be treated on par with cultivable land, and accordingly it would be appropriate to allow a deduction of 10% from the market value. Accordingly, insofar as 10 acres is concerned, market value is fixed at 12,70,000, and so far as Kharab of 2 acres 5 guntas, market value is fixed at 12,70,000 less 10%. Full stop. The enhancement would obviously include all statutory benefits. Accordingly, said appeals are disposed of, allowed.
The statutory benefits will be in addition to, my lord, the enhancement. Enhancement will not include, my lord.
And needless to state, statutory benefits. The enhancement would include not only enhancement in market value, but in addition.
With all statutory benefits.
Lordship may say, my lord, in enhancement along with, my lord, all statutory.
Statutory
Is
benefits.
entitled for so and so enhancement.
Now, the enhancement of as referred to above would also entitle the appellant to all consequential statutory benefits.
Please.
One sentence admin. Insofar as the Kharab is concerned, it is also to be noticed that in terms of the government order, terms of circular dated 8 December 1971, it is which has been produced by counsel for the appellant. It is clear that except that Kharab that is reserved for government or assigned for any public purposes, the remaining would vest with the owner of the land. And accordingly, in terms of the said circular also, all rights in a Kharab land would vest with the claimant, and claimant would be entitled to claim compensation as regards such land as well.
Circular, I request your lordship to mention the circular bearing number also.
A number ಕಾಣಿಸಲ್ಲ. ಅದೇನು
RD 136
RD 136.
LCS ಅಂತ ಇರ್ಬೋದು ಅಥವಾ LGS ಇದೆ 71 ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
LGS.
LGS dot 71.
Please.
But I'm not entitled for interest of my lord 1,109.
delay period.
Delay period, my lord.
Appellant will not be entitled for interest as regards the period, delayed period.
1,000
Period of delay in filing of the appeal
appeal, 1,109 days, my lord.
of 1,109 days.
9 days.
The
In light of the order sheet, IA 1 of 16 is allowed and delay of 1,109 days in filing the appeal is condoned excepting the cost shown.
11,43,000 ಆಗುತ್ತೆ ಸ್ವಾಮಿ. 10%
Port
deduct
Kharab
ಆದ್ಮೇಲೆ.
land, my lord. Port Kharab land will be
Port
11,43,000. That figure also.
7,43,000.
But good.
Obliged. I'll.
9, Arun Kumar Amaragundappa.
Yes.
I may have to pay it some deficit court fee, my lord, for which 8 weeks time may be granted, which is already granted in the connected.
Appellant is
8 weeks
is granted a period of 8 weeks
for payment of deficit court fee.
for payment of deficit court fee. You anyhow, that amount you are not going to get in 8 weeks. You rather pay it earlier.
Yes,
That
we will-
amount you will not get in 8 weeks. You pay it.
yes, yes.
Yes, yes.
Appeal could be allowed with cost. I'll get back court fee.
Huh?
Appeal could be allowed with cost. Court fee will be refunded. It is allowed with cost.
Cost.
Wait.
Appeal is there.
My lord.
The relied judgment has also given cost.
ಕೊಡ್ತಾರೆ usually ಕಾಸ್ಟ್ ಕೊಡ್ತಾರೆ
Appeal
but
is-
here he has not paid the court fees. He has
Well, I have paid the court fee. Some portion, my lord, I may have.
Appeal is allowed with cost.
Great.
Now finally, Tengli is not going to take the decision fit for appeal. ಯಾರೋ ಒಬ್ನು ಕ್ಲರ್ಕ್ ಇರ್ತಾನೆ ಪುಟ್ ಅಪ್ ಮಾಡ್ತಾನೆ ಅಲ್ಲಿ ಮೇಲ್ ಹೋಗ್ಬಿಟ್ಟು ಫಿಟ್ ಫಾರ್ ಅಪೀಲ್ ಅಂತ ಹೋಗ್ಬಿಟ್ಟು. Yes.
Lord, that decision is.
That's why what happens,
Yes.
sometimes in court, we may not go deep in etc.
Yes.
But somewhere there,
Yes.
they will do it and when it goes there, one different picture is painted.
My lord, just my lord, off the record, my lord. Government also knows, my lord, this is an appropriate value. They also accept, my lord, this is something to be paid. But the difficulty is, my lord, arranging the funds. My lord,
Funds.
that's, my lord,
That
triggering
reason
them to
appeals
my
are there.
file, my lord, multiple, my lord, appeals. That is my, my lord, what I have observed from the, my lord, records. Of the record, because, my lord, all these matters, about 140 matters which are remitted back after such long litigation, they have come up with the same figures. It's unfortunate that, my lord, the courts are used as a tool to, my lord, defer, my lord, the payments. Those, my lord, batch of cases, lordships, my lord, just deferred. Value is, my lord, 1.5 lakh, 1 lakh, 1,20,000. And, my lord, from 90s, my lord, there is delay there, that's fantastic. Grateful.
Yes.
Number 9, Arun Kumar Amaragundappa.
Yes.
With
Yes.
your lordship's leave, the petitions have filed application for recalling and condonation of delay. The matter arises is this, your lordship, that was a recovery proceedings. And the Honorable High Court single bench dismissed it. And thereafter, I challenged it to be in the Supreme Court. And the Supreme Court firstly condoned the delay. And thereafter, when it came up before Honorable Justice Gogai and Ashok Bhushan, the lordship said that you better you file writ appeal and then you come to the Supreme Court. So I have withdrawn it. And there was a delay in proceeding. Some objections were raised in writ appeal. As a result of it, I could not comply because of my sickness. And I produced all the medical certificates along with my application for recalling.
IA 1 of 24 has been filed. Seeking for setting aside of the order dated 16 2018, dismissing the writ appeal. For recalling the order, dismissing the writ appeal. It is noticed that the appeal came to be dismissed. Therefore, the order ಅಲ್ಲಿ dismissal order
Order. Dismissal.
came to be dismissed as per order dated 6/3/2018 due to non-compliance of office objections. Now it's complied, is it?
Yes, huh?
Complaint.
Yes, sir.
ಆಗಿಲ್ಲ. Complaint ಮಾಡ್ಬಿಡಿ. Now I'll have it next week. You comply with the office. I'll give you permission.
Next week, complaint, office objection complaint.
All right. Great.
Week's time, granted for next week compliance. Relist the matter. Yeah, the appellant is permitted to comply with the office objection pending consideration of IA 1 of 2019. Relist the matter on.
Yes.
Any date. Any date.
ನೀವ್ ಹೇಳಿ, ನೀವ್ ಯಾವ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಿ?
ಲಿಸ್ಟ್ ಮಾಡೋದು ಡೇಟ್.
Next week, your lordship.
ಡೇಟ್ ಹೇಳಿ.
ಹಾ.
ಡೇಟ್.
2nd January.
Second.
2nd February.
On 2nd of February.
Holiday.
3rd.
3rd of February.
Great respect.
ಸರಿ ಬಟ್ಟೆ ಸರ್
Yes.
Lordship, this is a divorce petition.
Yes.
Lordship, Your Lordship, appellant is the husband. And the appellant is challenging the judgment passed in the matrimonial case number 193 of 21, passed
He's-
by the,
He served, is it?
yes, Your Lordship. The respondent notice served. 6 months back, she taken the notice, but she's not ready to accept the permanent alimony and she is not ready to join also. So that is my problem. And
ಎರಡ್ ಸತಿ serve ಆಗಿದೆ. He's not ready.
she is not ready.
ಒಂದ್ ಸತಿ ಹೋಗಿದೆ, ಎರಡ್ ಸತಿ.
And she personally talked with the appellant also in my office. And both are not ready to join each other. That is the fault. And my client is offering 25 lakhs as a permanent alimony. But she is not ready to accept the permanent alimony also. And she is not ready to join the company of the appellant also. And she left the. Please.
Permanent wedlock.
Yes, Your Lordship. And since from 7 years, they are living separately. Maybe in family court, we are not, we are failed to establish the cruelty. But as per the contention of the appellant beyond the records, so they are not interested to join the company of the each other. So, and she is not ready to came before the court, even if at the time of counseling, I suggest that the fees of that High Court counsel paid by appellant, we will provide the fees also. So you came before the High Court and you make your submission before this honorable court. But even if she is not ready and she is doing job in Bangalore, one private work is. So my grievance is, since from 7 years I am separated and she is not ready to join the company of me. And how many days I will
Correct.
without a marriage? That
You'll have to make out a case on merits.
please.
TCR has come.
Yes, Your Lordship. TCR received. But cruelty is not established as per the observation made by below court.
Now, how do we, she's not there. Is there any way of serving her?
No, Your Lordship, I tried many times because that 6 months back, she approached me, she came to my office and they talked together and but they are both are not interested to live with that husband and wife, and they loses their affection as well as love also by observing that thing.
Is it possible to serve hand summons?
No, my contact number is also there. She talked with me many times, Your Lordship. That is one more chance will be given. I will serve. That is also possible. But
Hand summons.
hand summons, parvagil, kodi.
Appellant
Please.
is permitted to take out notice by way of hand summons, as well as to the WhatsApp number of the
Please,
appellant.
please.
Counsel for the appellant to file memo, along with memo, what's the mobile number of the appellant or of the respondent, to which WhatsApp notice would be sent.
Yes. And her elder sister's number is also there. In case she is not accepted that, please that alternative number I will provide.
Taking note that the respondent has already been served, the appellant, at request of appellant, the appellant submits that notice would also be sent regarding the pendency of proceedings to the WhatsApp number of other family members as well.
Please, please.
Memo to contain such details. List week after next date.
Date.
10th of February.
Please.
Jagat Shetty.
I am appearing for the complainant, ma'ams.
Yes.
I am appearing for the complainant. Annexes C and D are in Kannada version, ma'ams. As such, I have filed this.
1 of 24 is allowed, and complainant is dispensed with production of English translated copies of
Annexes C and D.
for the present. Yes, what is the matter?
Matter, your worship may kindly see, ma'am, the learned single judge disposed of the writ petition with a direction to the response, page number 9 minutes. Now, relevant page number.
Who has to consider it?
DC, Deputy Commissioner.
Issue notice.
First respondent has to consider, my lord. I will take notice for respondent 2, my lord. Will not issue notice to the first
Take
respondent.
notice for the second respondent. State emergent notice to the first respondent, returnable by date. Yes. One of 25 is allowed for dispensation of production of translated copies of annexure B, C, E, and F for the present. Yes.
I'll file the affidavit, kindly pass it.
This is the settlement. Also.
Number 30.
I am appearing for the petitioner, ma'am. The petitioner filed his application seeking leave of this honorable court.
You are not a party.
I was not a party before the tribunal, ma'am. Though I was a necessary party, I filed a writ petition against the father of the fourth respondent herein. That writ petition disposed of before the principal bench. Now he filed a application without making me as a party to the KAT, ma'am. In fact, the very tribunal.
No, it was only a challenge to an advertisement.
Yes, ma'am. He was appointed, earlier he was appointed, thereafter he has been relieved from service because he was appointed only for a period of 5 years, which was challenged before the tribunal.
No, who are you now?
I am the, your worship may kindly see, ma'am, the petitioner herein is a hereditary Valika, he hailing from hereditary Valika family. His grandfather was working as a Grama Sayaka.
I issue notice on IA as well as main. AGA is directed to accept notice for respondents 1, 2, 3. Emergent notice to the 4th respondent. Yes.
Okay. Surappa Heru.
But as per my lord's direction yesterday, I'm filing a affidavit.
Yes, Ms. Tengli.
I served the copy.
As per annexure A1, the deputation is only for 2 years. Even that that comes to an end in the September 2023 itself. Even thereafter, by the shelter of the interim order, he continued, and 24 is completely ended because of only 2 months. Matte not ಹೇಳಿ. That is the only.
ಅವ್ರ ಜೋರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸ್ಟೇ ಆಗ್ಬಿಟ್ರೆ ಇನ್ನು 2-3 ವರ್ಷ ಬರಲ್ಲ.
ಅದಕ್ಕೇನೆ ಅದೇ
ಅದು ಒಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ single judge was hearing the matter. It came up after a long time, and they saw the interim order in operation for 10 years. The deputation had lapsed 10 years back, and then they engaged the senior counsel for the protract. So I'm saying, so interim order ಕೊಟ್ಟು ಏನೇನು ಅನಾಹುತಗಳು ಆಗ್ತವೆ.
ಅದಕ್ಕೆ ಮಾರ್ಚ್ ಮುಗಿಯುತ್ತೆ.
Present writ petition has been filed. Pending the order of the KAT dated 10/9/2024, whereby the tribunal. Annexure A6 is the order.
Annexure A13 is the order.
No, KAT order.
KAT order annexure B, my lord.
Annexure
B.
page.
Annexure B, page number. Sorry, sir. Annexure C. I will page number 46, my lord.
Yes. Challenge order by KAT, whereby the tribunal has rejected to interfere with the order of withdrawal of deputation.
Lord.
Withdrawal of deputation.
Yes.
Order of withdrawal of deputation at annexure A13.
No, not that withdrawal different issue, my lord.
Other
It is
issue
second
where-
round once again.
Earlier.
In October 24, they have passed another order.
Just one minute.
Earlier.
Challenge before the KAT is annexure A13, isn't it?
Yes, my lord. Yes.
Ah.
Annexure A13 is passed in October 24.
No, what is that?
Subsequent to
Page
the
number-
application. Earlier
38.
application was withdrawn because my lord A5 was passed by the government, withdrawing the earlier transfer.
Because they have withdrawn the order, I have also withdrawn.
A5 goskara earlier withdrawn.
My lord, you'll find page number 38, annexure A13.
Of deputation at annexure A13. The said order has been challenged on various grounds in the present writ petition. But however, at the time of hearing, counsel Shri Hulappa Herur, in all fairness, submits that they would not press any of legal contentions if they are permitted to continue in the said post for a further period.
Till the end of this academic year.
Till the end of the academic year.
Academic year, my lord, overlapping March end of March or early April.
Affidavit is filed. Affidavit is filed to demonstrate his bona fides. Para 4 of the said affidavit reads as follows. Next. Taking note of the said undertaking in the form of an affidavit, it would be appropriate to dispose of the writ petition itself by deferring the implementation of annexure A13, which has not yet been implemented in light of interim order operating before the tribunal. Accordingly, operation of annexure A13 is deferred till 1st of April.
First week of April or 31st, end of March, exams will take place. End of April, my lord may say. For safer side.
ಮತ್ತೆ ಒಂದು ತಿಂಗಳು ಬೇಡ
For
End-
safer side,
end of the
April, even if
academic year.
February exams are over, I will go.
ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಅಂತೂ ಎಕ್ಸಾಮ್ ಇರಲ್ಲ.
ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಬಿಸಿಲು ಜಾಸ್ತಿ ಆಗ್ತದೆ, ನಾ ಮೊದಲೇ ಹೋಗ್ಬಿಡ್ತೀನಿ.
ರಿಸಲ್ಟ್ ಬರೋದಿದೆ ಅವಾಗ ಏಪ್ರಿಲ್ ಎಕ್ಸಾಮ್ ಇಲ್ಲ.
By 10th of April.
Yes, madam. Yes.
By 10th of April.
Yes, ma'am.
Full stop. Learned counsel for the petitioner submits that no further extension would be sought for. Full stop. Taking note that
Annexure C.
Taking note of the peculiar facts of this case and the matter is being disposed of only on the basis of undertaking, extending the time for coming into effect of annexure 813 till 10th of April.
Please.
Accordingly, till such date, the order of the KIT and annexure 813 are kept in abeyance.
Yes. Lord, one submission. Kindly pardon me. I pray for handover of the final order today because tomorrow day after holidays. Authorities may take advantage of this and relieve me from that. Yes, yes. As my Lord pleases.
Tengli is standing like a rock.
Yes, my Lord. Yes, my Lord pleases.
He will defend, he will take care of us.
Yes, great, great.
Till number 15. Jairaj ki book ka.
Lordship,
Yes.
the husband of the complainant is working as in the army defense. He died, my lord. Thereafter, the complainant filed a representation for sanction the pension. It's not sanctioned. The complainant preferred the writ petition 201292/2021.
Who has to consider?
The accused, my lord, 1 to 3, my lord. One ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. Additional Director General of Ministry of Defence Army, my lord. Given the representation, accused number 1 to 3, my lord. And thereafter, my lord, the writ petition order along with representation filed before the authority, my lord, till date is no considered as the petitioner preferred this contempt application, my lord, before this honorable. Issue notice to the other side.
The third respondent is the officer in charge, isn't it?
Sir, in charge, sir.
Issue notice for the present to respondent number 3. Relist the matter on.
10th of October.
Yes. Yes.
Till number 16. GG Chakashakti.
I am appearing for the complainant, man. Your Lordship may kindly see page number 12. The learned single judge disposed of the writ petition filed by the complainant with a direction to the fourth respondent to consider the representation within a period of 4 months, 3 months.
They filed an affidavit.
Yes.
They filed an affidavit. Affidavit ಹಾಕಿದ್ದಾರೆ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Lord, in this matter, my lord, kindly see the order of the learned single judge, my lord, page number 4, that is para number 4, my lord.
Copy of the affidavit you furnished to him. Let him have a look.
Given to the charge sheet team, my lord, I don't know, my lord, my learned friend is his colleague, my lord, I don't know whether it is received or not, my lord.
Tengli copy. ನಿಮ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ affidavit.
But kindly see for a moment, my lord, page number 4, my lord, because my lord, he is, my lord, making the complaint, my lord, to the Tahsildar. But there is no direction to the Tahsildar to consider it. But there is a direction, my lord, to the ADLR to consider the representation. But his work is already done. Kindly, that is my lord, para number 4, my lord, of the learned single judge order.
Let him have, I'll pass over, let him have a look at it.
But he has to make the Tahsildar as party. Otherwise, he has to seek the clarification before the single judge.
Next Monday or Tuesday, I have to get the copy in no affidavit is
I'll pass
forthcoming.
over, note it. And Sati note bidi, we'll ask him to give you a copy of that. Pass over. Put it.
For a moment, my lord, in this matter, my lord, he has to, for that is the reason, my lord, I'm making submission, my lord. We given the representation to the Tahsildar. For operative portion, kindly see, my lord, operative portion of the order, my lord.
Let him, correct, let him have a look at it. I passed over, let him have a look at it.
Please, my lord.
17.
17. JG Chagashetty.
I am appearing for the complaint. Your artist may kindly see, man, see one Imam Sahib.
What is the direction?
Direction is lower court to order mats.
Ah.
Your artist may kindly see one Imam Sahib filed OS number 60/2001 for partition and separate position. That suit came to be decreed in terms of the compromise mats.
No, injunction order, you're seeking, order 39 rule 2A, you have a remedy.
Yeah, your artist may first facts of the case are like this, mats. The one Qasim Sahib filed a suit, OS number 61/2001 for partition and separate position, which ended in compromise mats. Thereafter, the complainant herein filed FDP number 33/2003. During pending consideration of the FDP final degree proceedings mats, the respondent herein illegally constructed the proceeded to construct the building mats in suit property 328/2003, 228/3. Accordingly, the complaint filed IA number 2 under Order 39 Rule 1 and 2 minutes. That came to be allowed by the order dated 11/9/23 wide annexure B. In spite of injunction order operating against the judgment data, he did not stop the construction. He proceeded with the construction. That is why I filed one more application. She missed 6/23 under our 39 Rule 2A.
6/?
She missed 6/23.
What happened in that?
This also, your archivist may kindly see marks 39 2A. I one seeking police protection mats, which came to be allowed, and directed the police to protect the interest of the complainant. Your archivist may kindly see annexure C. Allow the annexure C.
Yes.
Page number 24 minutes. 29.
Now what happened 39 Rule 2A, what happened?
39 Rule 2A, police protection is provided mats. To the during pending consideration of the 39 2A, further started construction mats. That is why I filed an application, IA1, seeking direction, seeking to provide police protection. That is also allowed mats. In the your archivist may kindly see mats, the annexure D. The person whom a direction is issued, he states like this, your archivist may kindly see, he is also party to the contempt petition. Page number 27 minutes. ಮಾನ್ಯ ಗಣನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ದಿನಾಂಕ 17/6/24 ನಾನು ಖುದ್ದಾಗಿ ಮುರುಟಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 328 ಪೈಕಿ 1ನೇ ಭಾಗ ಅಗಲ 180 ಅಡಿ ಜಾಗೆಗೆ ಭೇಟಿ ಕೊಟ್ಟು ಅರ್ಜಿದಾರರಿಗೆ ಮತ್ತು ಎದುರಾದ ಕರೆಯಿಸಿ ಪರಿಶೀಲಿಸಾಗಿ ಅರ್ಜಿದಾರರು ಹೇಳಿದ ಜಾಗದಲ್ಲಿ ಅಬ್ಬಾಸ್ ಅಲಿ ತಂದೆ ದವಲ್ಸಾ ಕಣ್ಣಿ ಸಾಕಿನ್
ಮೋರ್ಟಿಸ್ ಹಾಕಿನ ಆದ್ಮೇಲೆ ಇವರು ಯಾವುದೇ ರೀತಿಯ ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. It is proved before the court, man. The police says that matters, it is, they are not proceeded with the construction matters. I have produced materials before the court while considering my application under Order 39-2A as well as the application filed under Order 39 Rule 2A.
No, but you'll have to file a writ to seek for enforcement of that order, contempt how will. No, we can't inquire into this.
I am not, you are also, in spite of court orders, matters. In spite of court order, the respond number 2, respond number 1,
Issue notice to the accused. Relist the matter on. No.
Number 19, M.A. Jagirdar.
To respond number 2 ಮಾಡಿದಾರ. Issue notice to respond number 2. Registry is directed
Interim
to
application is there where this accused number 6 is a woman having 3 small children.
SC/ST is
And
there. SC/ST is there.
Ides
So
party
notice has to go.
avarigu party ಮಾಡಿದ್ದೇವೆ.
Notice has to go.
Notice and complaint class
Before considering your IA, notice has to go. Sorry.
short date.
After service of notice.
Yes, ಅದೇ 1 week timing. ಯಾಕಂದ್ರೆ ನಡು ಒಂದು ತಿಂಗಳು ಏನಪ್ಪಾ ಅಂದ್ರೆ ವೆಕೇಶನ್ ಇರೋದ್ರಿಂದ ಏನೋ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. More than 2 months she is in judicial custody.
Additionally, additional SPP is directed to intimate pre-respond number 2 telephonically. State additional SPP is directed to take notice to R1 ಅಂತ ಮಾಡಿ. Accept notice to R1. Returnable date ಕೊಟ್ಟು. Four.
Number 20, Patil Shantabai.
Appearing for appellant, my lord. It's a wife's appeal, my lord. Ex parte divorce decree is passed against her, my lord. Being agreed by that, she approached to this court, my lord.
You did not contest, notice is not served. What happened?
Notice is recorded as refused, my lord, but the.
Not served according to you.
No, not served.
How much is the delay?
There is no delay.
No delay.
No.
When is the order passed?
Order at next page number 12, starts 12 to.
1st of August. When you have filed
20.
immediately, is it?
Yes, my lord, immediately thereafter I have.
Issue notice.
Notice is already respondent
not
appeal,
record,
my lord.
So ex parte they're saying.
Expect, I will collect the copies, my lord. I'm having only wakalat copy.
I have
TCR, immediate actors. TCR to be summoned telephonically. List the matter, date kodi first week. We'll have a look at the notices sent, etc. and we'll have to go back on.
Please.
In the
interim order में kindly extend.
respondent is restrained from contracting any fresh matrimonial relation, contracting any fresh marriage, pending consideration of present appeal. This is the matter on 5th.
Much.
Number 21,
Are you married or no? Again,
I'm not having any instructions, my lord. I will
Trying to
seek
give-
instructions.
He is trying to marry. He has orally scholar.
right, you must ask for interim prayer, isn't it?
My lord, as
They're
per,
not pressing only.
no, my lord, after getting decree of divorce,
I'm not saying you must press for an interim prayer.
already this court has granted
Granted.
interim order. That may be extended, my lord.
The order earlier granted is extended till the next date. Immediately. Stay one, not to marry. ಇದು ಇರ್ಲಿ. ಇದು ಇರ್ಲಿ. Further, immediately as it is. Further, the interim order on 15/10/2024 is extended until further order.
That's it.
Twenty-one, Rajesh Dodman.
Convicted and pray for 376-2M.
Issue notice to R2.
No, there is no R2 bullets.
Huh?
R2 ಇಲ್ಲ. 376 and
Not
2. 302.
ಮಾಡಿದ್ರಲ್ವಾ?
ಇಲ್ಲ.
Rape and murder ಅಲ್ವಾ?
Rape and murder. Rape is for 376 and 302.
302, 376.
Yes.
R2 ಗೆ notice
Yes.
ಹೋಗ್ಲಿಲ್ವಾ? Minor ಅಲ್ಲ?
Minor.
Minor ಆ?
Not a minor ಇದ್ರೆ ಪೋಕ್ಸೋ.
Yes. Not
Next week bullets.
next week, huh?
He was on bail during trial.
Yes. Re-notify, ಒಂದು date ಕೊಟ್ಬಿಡಿ. ಯಾವಾಗ? Third, fourth.
That earlier which
in
was
the
given on
meantime.
4/2 mellots
Huh?
on same day. Earlier.
Fourth, ಆಯ್ತು. In the meantime.
4/2.
SPP is permitted to file.
Please.
Section if any to IA number 1 of 25.
Yes, please. Follow.
TCR ಬರ್ಲಾ? TCR call for ಮಾಡ್ಬಿಡಿ.
Yes, yes, madam.
Registry directed to secure the TCR. Relief money.
Manjunath Mallaya Shetty.
My Lordship, I am referring behalf of Manjunath Mallaya Shetty, my lord. It is a corporation appeal. Meanwhile, we are sought for stay, my lord. We are challenging liability on the ground of contributory negligence. 2 vehicles are involved, my lordship.
Challenging
Contributory negligence, my lord.
contributory.
2 vehicles are involved.
Accepting the reason assigned in the IA affidavit accompanied to IA number 1 of 2025, the operation and execution of the the judgment and award passed, award passed by the tribunal is stayed subject to the condition that the appellate depositing 50% of
Please.
the award amount before this court within 4 weeks.
Please.
4 weeks from today. It is made clear that the respondents are permitted to withdraw. On such deposit, the respondents are permitted to withdraw the 50% of the deposit. 50% of the
Notice to
deposit.
R1, please. Notice to R1 to R6, my lordship. R7 is a new India, any standing council. Preeti Patil.
R1 to R6, the Srimati Preeti Patil Melkundi is direct to accept notice to respond number 7.
7. Obliged.
It is directed to secure the transport.
Obliged.
Ramachandra K.
We have challenged the impugned order passed by the family court. Divorce petition filed by the respondent was allowed without considering the facts, my lord. Respondent number 1 filed a divorce petition against the appellant on the ground that cruelty.
You have filed within time.
Yes, ma'am.
Or delay.
Yes.
Within time. Issue notice to the respondents call for TCR. In the interregnum, respondent not to contract any fresh marriage.
IA may be considered, my lord. Yes.
Respondent is restrained.
Please.
Yes.
34, Amir Hamas.
Some other day, we are getting up at 1:30. I'll repeat it when you want it.
He's held up in other court.
No, not today.
Monday, on Monday.
Monday. Yes. We have one criminal appeal we are trying to finish. Yes.
RJ Busare.
Kindly be taken next.
He lists the matter. Date.
Usari also requested.
He lists- Yes.
Till number 35. Additional SPP.
ಫೈಲ್
ಇಲ್ಲಿ ಹೊರಗಡೆ ಇರ್ತಾನೆ.
ಇಲ್ಲ ಫೈಲ್ ಮಾಡಿ ತರ್ತೀನಿ ಅಂತ
ಆಫೀಸ್ ಇಲ್ಲೇ ಒಳಗಡೆ ಇದೆಯಲ್ಲ,
ಮೆಲ್ಲೋಡ್
ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇದೆ.
ಹೋಗುವ.
ಬನ್ನಿ ರಮೇಶ್, ಬನ್ನಿ. ನೋಡಿ ಬರ್ತಾ ಹೋಗೋಣ. ಬರ್ತಾರೆ ಸ್ಕೂಲ್.
Minutes, sir.
Yes.
Synopsis. Number 164 and along with 179.
Yes, Mr. Legally, now come to evidence of PW 5 and 7.
Yes, ma'am. 5 lords has not supported.
Netherlands Session Judge, 5 and 7.
Yes, ma'am.
Huh.
5 lords has turned hostile.
Huh.
And
Party turned hostile.
yes, my lord. She does not say or identify the accused. So far as PW 7 lords, he is a chance witness because he does not stay in the vicinity nor has a working his calling at nearby that place, my lords. He says that he had gone to the marriage, and on that day, my lords, he happened to have witnessed the incident.
Now
And
just
the
come to the evidence of PW 7.
yes, my lord.
It's 92.
Yes, ma'am. May I read, my lords?
92.
Yes, ma'am. I know PW1 Asrar. I knew deceased Amira Parveen. PW1 Asrar is the son of deceased Amina Parveen. I know PW6 Afsar Ahmed, who is the brother of Amira Parveen. I know A1 Abdul Hamid. I know A2 Abdul Wahid and A3 Majid, who are present before the court. Since they are coming along with A1 Abdul Hamid for purpose of purchase of mutton to my shop, PW6 Afsar Ahmed is also my customer. PW6 Afsar Ahmed was telling me before me that his sister Amira Parveen has been given in marriage to A1 Abdul Hamid and that he was ill-treating her. On 15/6/2023, I had been to Adil Shahi Marriage Hall to attend a marriage situated in Sheikh Colony at Hakim Chowk, Vijaypura, along with CW20 Karim Khan. While going for the said marriage, when we came near the Pahad Khan Masjid complex at about 1:30 p.m., myself and Karim had stopped there near the said complex. At that time, these two accused, Abdul Wahid and Majid, came on a Pulsar motorcycle and were shuttling before the Hakim Colony and Hakim Chowk and Sheikh Colony. Accused Majid was riding the motorcycle, whereas Abdul Wahid was the pillion rider having baseball bat. In the meantime, two ladies in burqa were coming from Sheikh Colony. These accused parked their vehicle near the land of Sheikh. The accused Wahid assaulted one of the lady coming from Sheikh Colony with baseball bat on the back side of the head, coming from hind side of that lady, due to which that lady fell down. Another lady, being frightened by that, ran towards us. Accused Majid sped away on the motorcycle towards Hakim Chowk, whereas accused Wahid ran with the baseball bat towards the Sheikh Colony. Number of people gathered there, including us. On seeing her, we came to know that the injured lady was the sister of PW6 Afsar Ahmed. In the meantime, 108 ambulance came and injured lady was shifted to hospital. Myself and Karim did not go to the marriage and returned to our home. Later on, I came to know that said lady died in the hospital. Later on, I came to know that PW1 Asrar has given complaint against Abdul Hamid alias Munna Bagli. On 18/6/2023, myself and CW20 Karim went to Golgumas police station and gave our statement. Thereafter, on 24/6/2013, we were summoned by the Golgumas police station and recorded further statement. We came to know that even Munna and his wife, Amira Parveen, were not in good terms. Therefore, he got murdered, his wife, through accused number 2, Wahid, and accused number 3, Majid. I can identify the baseball bat, MO9, now shown to me is the same. I can identify the Pulsar motor vehicle if shown to me. MO8 now shown to me is the same vehicle on which these accused Wahid and Majid came on that day. Cross-examination. My house is situated in Shahpur Gate of Vijaypura. It is true that my house is at a distance of 6 to 7 kilometers from the scene of occurrence. Myself, my parents, my brother together reside in our house. CW20, Karim's house is also situated near my house. Till 18/6/2013, Police have not approached us and inquired us. PW6 Afsar Ahmed comes to my shop 2 to 3 times in a week, including PW1 Asrar. I have seen their house. We exchange our views regarding our family affairs. I do not remember the name of the bridegroom for whose marriage ceremony myself and CW20 Karim were proceeding. It is true that said marriage hall is also at a distance of 7 kilometers from our marriage. Distance between Hakim Chowk and Sheikh Colony is about 5 minutes walk. Distance between Pahad Khan Dargah complex and Adil Shahi marriage hall is about 8 to 10 minutes walk. It is true that the road is a busy road. On that day, we did not meet PW1 Asrar. We did not go to the house of PW6 Afsar and informed about this incident. I had informed about this incident in my house to my father. Myself and my father did not try to contact PW6 Afsar on phone and informed about this incident. I do not know the registration number of the motorcycle on which these two accused came. I do not know the father's name of A2 Abdul Wahid and that of A3 Majid. I do not know where their houses are situated. What is their avocation? We did not talk to accused Wahid and Majid on that day. I know these accused since many years as they come to my shop for purchase of mutton. On that day, myself and Karim left our shop by walk to attend the marriage. Accused Wahid assaulted that lady with baseball bat only once on her head. Her clothes, including burqa, got blood-stained. It is not true to suggest that I have not stated in my statement dated 18/6/2013 that Majid was coming on my shop for purchase of mutton. Being afraid of that scene, I did not accompany the injured lady to the hospital. It is not true to suggest that no such incident as deposed by me is taken place and that I had no such occasion to witness any such incident. It is not true to suggest that I am deposing falsely at the instance of PW6 Afsar Ahmed. It is true that. So, Lords, this is the case, Lords. Lords, kindly appreciate. This witness is a close associate of the PW6 Afsar Ahmed. Afsar Ahmed, my lords, who runs a chicken center, my lords. And he used to regularly visit him. In fact, weekly.
Know about the death of this.
The very day, my lords, very day.
No, that she was the relative of PW6.
He knows, my lords.
When you came to know?
On that day, my lords, kindly see.
Same lady anta.
Same lady, alle ಹೇಳ್ತಾರಲ್ಲ ಸ್ವಾಮಿ. Because kindly see, my lords.
What identified initially?
6, my lords. 6, para 6, my lords.
Para 6 ಏನು ಹೇಳ್ತಾರೆ?
Number of people gathered there, including us. On seeing her, we came to know that the injured lady was sister of PW6. So he knew.
Subsequently, he met PW6. Subsequently, he met PW6 before 18.
No, my lord, he does not meet. There is no mention about that. In fact, in cross-examination, it is elicited that did he make any attempt? He says that he has disclosed it to his father. Then question was posed saying that has he made any attempt to meet the PW6 so as to inform him, since they were privy, they were known to each other very well. In fact, notes, if we see, he says that PW6 and he used to exchange views about their family, because he says PW6 Afsar is also my customer. PW6 Afsar was telling before me that his sister Amira Parveen has been given in marriage to A1 Abdul Hamid and that he was ill-treating her. This shows, my lords, that they were close enough that they could discuss their personal problems with each other. And now, my lords, in the cross-examination also, he says every weekly 2 to 3 times he would go to their mutton shop. Because, my lords, Afsar Ahmed, my lords, is a renowned chicken center in Bijapur. So regularly he goes to his shop. And that is the reason why, my lords, the trial court holds that. And he, in his cross-examination, says, kindly see, my lords, he says, on the day of incident, myself, para 6, my lords, cross-examination. On the day of incident, myself and Karim left our shop by walk to attend marriage. When they go by walk, where is the question of they being on motorcycle? So, my lords, the trial court, my lords, considering all these aspects, and yet another important aspect the trial court has attached is, my lords, evidence of PW6, my lords. He is the brother of Sir Ahmed Lafe, is the person, my lords. In his cross-examination, he admits that way back in 2011 itself, his brother, that is accused number 1, had divorced the deceased Amira Parveen, my lords, page number 91, my lords. Page number 91, second line, my lords. It is true that Mustafa Colony is at a distance of 1 kilometer from Golgumas police station. It is true that in the year 2011, accused number 1 had given talak to my sister, agreeing to pay rupees 10,000 maintenance per month. So way back in 2011 itself, there was divorce. So question of my lords, they living together or harassing does not arise. So my lords, the trial court holds that the trial court, my lords, after appreciating all these aspects, holds that, my lords, the prosecution, though there is one eyewitness, is a chance witness, my lords, much credence cannot be attached to his deposition, and they have rightly rejected his evidence, my lords. May I take?
PW5.
She does not.
Was going along with the deceased.
Deceased. She does not say that it is the accused who have assaulted, and it is for this reason that complainant, while giving complaint, does not speak about A2 and A3.
It is not identified. This.
Not identified. That is why the trial court says, though she has supported to some extent, but so far as the incident and participation of A2 and A3, she does not speak. And it is she, my lords, who had informed the complainant, Asrar Ahmed, my lords, who is the son of the deceased. And he lodges complaint suspecting that my mother's second husband might be involved. It is on suspicion, my lords.
That accused number 1, before the incident, immediately after the incident, accused number called that.
Called the, yes, my lords. Called the son of the Amira Parveen, stating that your mother has fallen at that Pahad complex, Dargah. And it appears that somebody has assaulted. He does not name anybody. And with that information, he goes, and the trial court says that cannot be possible, means. Kindly, at page number, my lords, complainant's evidence at page number 72, my lords. Para 8, may I request, my lords? Para 8.
It's not that. The tenor of that information by PW, that accused number 1 to PW1, that I only committed that.
If that were to be the case, my lords, the complaint contents would have been different, my lords. That is not the case. Now, kindly appreciate this para 8, my lords. Of the
PW?
PW1, my lords. Complainant. Page number 72. Para 8, my lords. In the hospital, I inquired CW9, Tabassum, that is PW5, my lords, as to how my mother sustained injury. She told me that when she along with my mother were returning from tailoring class, came near Hakim Chowk at about 1:45 p.m. Some 2 persons came on a motorcycle and hit my mother with a baseball bat on her head 2 to 3 times, and that after my mother fell down, they went away on the motorcycle. So if she knew, my lords, she would have stated them. So that is not the case. And my lords, kindly see the yet another reason why the trial court rejects the evidence of eyewitnesses, that, my lords, that he specifically says the only assault was once. Even in cross-examination, it is reconfirmed that he assaulted only once. Whereas if my lords may see the post-mortem report, the deceased had sustained as many as 9 injuries, my lords. And that is the reason why trial court holds that what has been presented by PW7 may not be the entire truth. It is the subversion of the incident which is presented by him, rendering his evidence to be unsafe, and has rightly rejected his evidence, my lords. Because, my lords, kindly appreciate, the trial court, my lords, is the first court of recording evidence. It has the advantage of seeing the demeanor of the witness. And that is why, my lords, when the court, after assessing all these aspects, holds that the accused holds that a benefit of doubt can be extended to the accused, disbelieving the evidence of PW7, my lords, that will have to be given some importance, my lords, because if it is not a plain case where, my lords, in the complaint all the persons were named, maybe I would not have stood a chance to submit, my lords. But now, my lords, things are not very clear. And after 3 days, the eyewitness, who was so privy to the complainant and his brother PW6, my lords, keeps quiet and then goes. So, my lords, the trial court holds that he was planted by the prosecution, considering the fact that PW6, my lords, has planted him. And the trial court has because way back in 2011 itself, there was divorce. PW6, the brother, has clearly supported that aspect notes. He says there was talaq given. So probability of they living together may not arise notes.
Yes, yes, PP.
And
My lords, PW5 turned hostile, so-called, she was along with the deceased, my lords, and she has not supported the case of the prosecution. And my submission would be, my lords, as far as this PW7 eyewitness is concerned. His statement has been recorded on 18th. The incident is said to have occurred on
3 days delay in recording statement.
Yes. And also as far as PM report is concerned, as learned counsel has stated that there were 9 injuries on the body, but the hit is only 1. To that effect, my lords, as far as PM is concerned, I don't have case. But as far as this PW7 is concerned and 6 and 7, they have supported the case of the prosecution, and PW1, this accused number 1 has telephonically called and this shows the
See, as per the incident on the relevant date is concerned, PW5 supported.
yes,
She stated
she stated
that somebody assaulted.
on 15th.
Yes, somebody assaulted. They came to the in a bike and on her behind, they assaulted on her head. That is that due to the assault, she fell on the
She fell
road.
down.
Yes, so that is clear. Now, the subsequent version deposed by PW7 that these 2 persons are assaulted. So there is a corroboration.
Lords, delay, my lords, and there is delay, my lords, because he was known to each other. They were known. If had it been, my lords, because he clearly it is elicited that he knew the complainant, he knew the brother PW6. They were visiting every week thrice to his mutton shop. And it is not just a customer and vendor relation, my lords. They had more to, the relation was more, if I may say, my lords, they were more connected to each other because they used to discuss their personal problems. He says that, my lords, the PW6 said that my sister had married accused number 1 and he was ill-treating her. And even in cross-examination, this witness says that we used to exchange views about our families. So it can't be merely a customer and a vendor relation.
What is the vengeance with the accuser? Number 1 or 2 to 3? 2 and 3. PW7, what is the vengeance? To depose falsely or to implicate accuser?
So far as presence of A1, lords, it is the case of the prosecution that he was not there on the spot. Now, my lords,
2 and 3.
2 and 3, they'll have to submit.
Suggestion. What you
My submission would be, my lords,
what you suggested to this witness, PW7? Why they falsely implicated? Why they falsely deposed evidence against you?
our suggestion is that, my lords, he is deposing against them on the count of the bad marriage between accused number 1 and the deceased Amira Parveen. And PW6 is the person who has set up these witnesses, my lords. On that count, my lords, that is the suggestion made at para 8, stating that he is deposing at the instance of PW6. And PW6 is hostile to accused number 1 for the reason that, my lords, they had bad marriage. Sister's marriage had gone bad with the accused number 1. That is why, my lords, they have. And in fact, even the complainant would say, only on suspicion I have lodged complaint against the accused number 1. He admits in the cross-examination. And the trial court says, my lords, the trial court after appreciating states that it is highly improbable or unlikely that accused number 1 would have called and stated to accuse PW1, the complainant, about the incident. That is the reasoning given by the court. Considering the hostility between the parties, it would be highly improbable that he would have called her. And my lords, he is a so far as
shows his ego, prestige. Nannನ್ನು ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ, ಡಿವೋರ್ಸ್ ಕೊಟ್ಟಿದ್ದು ನೋಡಿ, ಮರ್ಡರ್ ಮಾಡಿ ಹಾಕಿದ್ದೇನೆ ರೋಡಲ್ಲಿ. ತಗೋ. That was the tender. That was
my lords, the divorce took place in the year 2011, my lords. Incident takes place in the year 2013. After 2 years, my lords. I could have understood, my lords, if it had happened in a remote or a short time, maybe 2-3 months, up to 6 months. It's almost more than 2 years that they've been living separately.
No, that is not the reason, my lords. When she started going to tailoring, which he opposed, this particular appellant number 1, my lords, because of that, this incident is occurred. In spite of opposing by the appellant number 1, my lords, she did not hear.
And it is a busy locality.
So on acquittal, how can we what is required for interference?
Lords, my respectful
Legal position. If we are to now interfere, what according to you will come in the way of interference?
Firstly, my lords, it is an order of acquittal. And once it is an order of acquittal, the presumption of innocence, my lords, would be strengthened by the trial court's acquittal. My lords, in this regard, my lords, I would want to rely on a judgment of Honorable Supreme Court, Anwar Ali versus State of Himachal Pradesh, where the Honorable Supreme Court, my lords, has reaffirmed the already they have relied upon the judgment of, there are several catena of judgments, my lords, and the judgment in case of Chandrappa versus State of Karnataka, my lords, reported in 2007. Lords, I would submit that it would succinctly, broadly place the principles, my lords. I request, my lords, to kindly see para 15, page number 108, my lords, 408, beg your pardon, 408. Page number 408. There, my lords, a reference to a judgment in Chandrappa versus State of Karnataka. This court reiterated the legal position as under. 1. These are the 5 instances, my lords, where the High Court, where the appellate court, the manner in which they'll have to exercise their power in cases of acquittal appeal, my lords. 1. An appellate court has full power to review, reappreciate, and reconsider the evidence upon which the order of acquittal is founded. The Code of Criminal Procedure puts no limits, restrictions, or conditions on exercise of such power, and an appellate court, on the evidence before it, may reach its own conclusion both on question of fact and of law. 3. Various expressions such as substantial and compelling reasons, good and sufficient grounds, very strong circumstance, distorted conclusion, glaring mistakes, etc., are not intended to curtail the extensive powers of an appellate court in an appeal against acquittal. Such phraseologies are more in the nature of flourishes of language to emphasize the reluctance of an appellate court to interfere with acquittal than to curtail the power of the court to review the evidence and to come to its own conclusion. 4. An appellate court, however, must bear in mind that in case of acquittal, there is a double presumption in favor of the accused. Firstly, the presumption of innocence is available to him under the fundamental principle of criminal jurisprudence, that every person shall be presumed to be innocent unless he is proved guilty by a competent court of law. Secondly, the accused having secured his acquittal, the presumption of innocence is further reinforced, reaffirmed, and strengthened by the trial court. 5. If 2 reasonable conclusions are possible on the basis of the evidence on record, the appellate court should not disturb the finding of acquittal recorded by the trial court. So, my lords, my respectful submission is, my lords, now the trial court, for every count, my lords, the trial court has given its explanation. It says, my lords, as to why this chance witness should not be believed. PW7, he's a chance witness because And there are three factors, my lords. One is delay in recording the statement of the PW7. And secondly, my lords, the evidence deposed by him is in contradiction to the medical evidence. And thirdly, my lords, he's a chance witness. All these aspects, my lords, the trial court has appreciated and has held that he cannot be believed. And my lords, it is, as I've submitted, my lords, so far as chance witness, my lords, at the outrightly, my lords, he cannot be, the trial court will have to go.
What is the exact definition of chance witness?
Person, my lords, who by chance witnesses the incident. He is not the natural resident. For example, my lords, if natural witnesses are those, when, for example, in a house, if husband and wife reside, and if the husband is being murdered, wife in his house, the natural person, natural witness who is expected to be with him is the wife or the children or the relatives. Whereas chance witness, my lords, would be a person, for example, it can be a guest who generally does not reside with them, but he will have to explain his presence at the place because it is not his regular place of residence or workplace. So, my lords, he'll have to explain his purpose for his presence at the,
Suddenly appears and thereafter disappears from the scene of occurrence.
yes, here, my lords, it is not admittedly in the cross-examination. He says that his house is about 7 kilometers away from his, the place of incident is about 7 kilometers away from his house. And he admits that he had gone for a marriage.
Witness not disappeared. The police recorded a statement late after 3 days.
Yeah,
That is the lack of investigation officer.
Yes. My lords,
All the cases SPP, we are sorry to say this,
Yes.
kind of investigation, this will lead somewhere else. The police officer in all the cases, this stereotype, this one investigation and a totally faulty investigation.
Yes, I do agree.
When eyewitness available on that day, after 3 days, you recorded their statement.
And even, my lords, the call records would have been ascertained and PW1's
Other case, we will direct this one commissioner or
placement.
the authority.
Yes. Even in some cases, injured have not been cited as even witness, my lords. For the last, my lords have seen that. That is the main faulty investigation, I feel.
Yes, serious offense.
And also, my lords,
Serious
the person who took injured to the hospital, his statement hasn't been recorded and he has not been cited as a witness. Otherwise, in that 4 series case, the thing would have been different, my lords. If 2 things could have been done.
But the state has preferred this appeal. These appeals, sorry. The state has preferred these appeals against the judgment passed in SC number 212 of 2013 and SC number 24 of 2015 dated 23/4/2016 by the second additional session judge Vijaypura, whereby the learned session judge has acquitted the appellant accused number
123 minutes.
Accused number 123 for the charges leveled against him for them for the offense punishable under section 302, 498A, 109, 302 read with 34 of IPC. Full stop. The abridged facts of the prosecution case are that the marriage, abridged facts of the prosecution case are that the marriage between accused number 1 in this accused number 1 and the deceased in this case, Amina Praveen, was second marriage, as her first husband was divorced. Full stop. The, it is a further case of the prosecution that accused number 1 was ill-treating deceased Amina Parveen by harassing, by ill-treating her by giving physical and mental cruelty, full stop. Cruelty, comma, whenever she demanded money for her livelihood, full stop. On this backdrop, comma, on 15/6/2013 at 1:45 p.m., comma, the accused number 1 instigated his subordinates, they are the subordinates, instigated
Subordinates.
his subordinates, that is accused number 2 and 3, to commit the murder of his wife Amira Parveen, comma, in furtherance of such instigation, by accused number 1, the accused number 2 and 3 came on a motorcycle belonged to accused number 1 and assaulted Parveen while she was returning home from her tailoring class, full shop. It is stated that accused number 2 assaulted her with the baseball bat on the backside of her head and accused number 3 was riding the motorcycle, and thereby, comma, due to the assault, she fell on the road and thereafter succumbed to the injuries, full stop. These injuries. After this incident, comma, it is the incident. It is the case of the prosecution that after this incident, the accused number 1 called PW1, who is the son of deceased, the son of deceased Parveen, comma, and informed that the dead body of informed that his mother was assaulted by somebody and a corpus was lying on the road, full stop. Accordingly, he rushed to the spot and thereafter, comma, lodged a complaint against his father, accused number 1, on suspicion that since he was informed about the incident by him,
Accused number.
by him, full stop. As per exhibit P1, comma, based on such information, comma, the respondent police registered a case in registered a case against accused number 1 in crime number 184 of 2013, dated 15/6/2013, for the offence punishable under section 498A, 109, 302, with 34 IPC. Accused number 1 and others, accused number 1 and two others. Two others, full stop. Thereafter, two others. Thereafter, the investigation officer, conducted the further investigation and recorded the statement of PW5, PW5, who was the colleague of the deceased Parveena and who was along with her at the time of incident. So also PW7, the eyewitness to the incident, eyewitness to the incident, full show. Subsequently, based on their statement, subsequently the accused was arrested and based on their voluntary statement, the weapons used for the commission of the crime, recovered at their instance under Mahaz's Exhibit P, under Mahaz's Exhibit P16,
Yes.
Exhibit P16, Nodi.
Yes, ma'am.
Exhibit
P16.
P16, full stop, Exhibit P16. Subsequently, after recording the statement of other material witness, so also obtaining the documents from the concerned authority, PW11 laid the charge sheet before the committal court, full stop. After committal of the case before the session court, the learned session judge framed the charges against the accused for the aforementioned offences, and read over the same to the accused, the same denied by the accused, and they claim it to be tried, full stop. In order to prove the charges leveled against the accused, the prosecution before the trial court, the prosecution in total examined 11 witnesses, so also and got marked 26 documents. So also 11. So also got identified 11 material objects. Next, post assessment of the oral and documentary evidence, the learned session judge acquitted the accused for the charges leveled against them. The charges leveled against them. The said judgment is challenged by all the accused. That is more specifically the said judgment is challenged by the state. In these appeals, that is more specifically, the state has preferred the criminal appeal, state has preferred criminal appeal 200179 of 2016 against the judgment passed in SC number
24 of 2015.
and filed criminal appeal number 200164 of 2016 against the judgment passed in SC number
212 of
2013. Correct, Alva?
Yes, correct.
2013. Next. We have heard the learned additional SPP Shri Patil for the state, for the appellant state. So also Shri Lagli for the respondent accused. Full show. Shri Patil, learned SPP, would contend that the judgment under this appeal is suffers from perversity and illegality. Since the learned session judge failed to appreciate the evidence on record in a right perspective and acquitted the accused in spite of prosecution placing sufficient evidence to prove the charges leveled against the accused. Full. He would further submit, the prosecution has examined, relied the evidence of the prosecution has proved the act of accused by placing the evidence of eyewitnesses PW5 and PW5 and PW7. These two witnesses have categorically stated about the incident, and the incident committed by the accused. Full stop. Further, the PW1 complainant examined as PW1 lodged the PW1 being the son of deceased lodged the complaint soon after the incident, by mentioning the name of accused number one and other two persons, in the said complaint, two persons, full stop. The contents of exhibit P1, clearly corroborates to the oral evidence of PW1, full stop. The prosecution also relied the evidence of, also placed the evidence of PW6.
Yes.
PW6, who is the brother of deceased. He also supported the case of prosecution. Full stop. In such circumstance, the learned session judge, without properly appreciating the evidence of these material witness, mechanically by relying on surmise and conjecture, acquitted the accused for the charges leveled against them. Accordingly, he prays to set aside the impugned judgment and impugned judgment passed by the trial court by allowing these two appeals. Full stop. Allowing these two appeals, and also to convict the accused for the charges leveled against them. Full stop. Per contra, she legally learned counsel for the respondent accused would submit that the learned session judge, after meticulously examining the evidence on record, passed a well-reasoned judgment which does not call for any interference. According to him, the evidence, material witness, that is PW5, the eyewitness to the incident, partially turned hostile, and she unable to identify the assailants. Further, the evidence of PW7, the one more eyewitness also suffers from severe infirmities for the reason that infirmities, full stop. Further, his statement was recorded by the respondent police after 3 days from the date of incident. So also on perusal of his evidence, it could be easily concluded that is a chance witness to the prosecution. Full stop. The said aspect was thoroughly examined by the learned session judge. Full stop. He would further contend that the evidence of PW1 and PW contend that much evident value cannot be attached to the evidence of PW1 and PW6, since they are the hearsay witness to the incident. Full stop. In such circumstance, full stop. Further, this being the appeals against the acquittal judgment, the judgment, while interfere as per the law laid down by the Honorable Apex Court in the curtain of judgment, the appellate court must see whether the view taken by the trial court while acquitting an accused can be reasonably taken on the basis of evidence on record. In this case, the trial court, the view of the trial court, the view taken by the trial court is a possible view. As such, interference does not call for. Accordingly, he prays to dismiss the appeal. Full stop. Having heard the learned counsel for the respective parties, so also having perused perusing the entire evidence on record, the only point that would arise for our consideration is whether the judgment under this appeal suffers from any perversity or illegality, and interference in the acquittal order passed by the trial court is called for by this court. Full stop. This court. full stop. We have carefully perused the entire evidence on record. In order to establish the guilt of the accused, in order to establish the charges leveled against the accused, the prosecution has examined 11 witnesses before the trial court. Among these witnesses, witness before this court. Full stop. As far as in order to prove the homicidal death of the deceased, deceased Parvanisha,
This is Apuravar.
Amira Parveen.
Amira Parveen.
Amira Parveen, the prosecution predominantly relied the evidence of PW9 Doctor Ramesh Patil, who conducted the autopsy on the corpus of the deceased and issued the post-mortem report as per Exhibit P20. On perusal of Exhibit P20, the PW9 has opined that the death is due to as a result of injuries sustained overhead. Full stop. Overhead. Full stop. Further, overhead. Further, the PW, the prosecution also the prosecution also relied the inquest Panchanama conducted on the corpus of the deceased by PW11 as per Exhibit P4. As could be seen from Exhibit P4, the investigation officer PW4 observed as many as 9 injuries on the corpus of the deceased. Full stop. Corpus of the deceased. Further, PW5, the witness who accompanied the deceased, was in the company of the accused deceased on the relevant date at the time of incident, clearly deposed before the court that some unknown persons assaulted the deceased, and due to the same, the deceased fell on the road. Due to the same, deceased sustained injury on her head and fell on the road. Thereafter, succumbed to the injuries. In such circumstance, in our considered view, the prosecution has proved the homicidal death of the deceased beyond reasonable doubt. However, to connect the accused for the homicidal death of the deceased, the prosecution mainly relied on the evidence of PW1, that is the son of deceased, who lodged the complaint as per Exhibit P1, the evidence of PW6 with the maternal uncle of the PW1, uncle of the deceased. Maternal uncle of the
brother of the deceased, maternal uncle of PW1.
Uncle of PW1. So also the evidence of PW5 and 7 were the eyewitness to the incident. Full stop. On witness to the incident. On perusal of the evidence of PW1 and PW7, PW1 and PW6, it could be the same depicts that the accused, the deceased, depicts that the accused was the husband of deceased, and in the year 2011, he divorced her, and thereafter, Thereafter, he was nourishing ill will against the deceased, against the deceased, against the deceased. Full stop. However, both the full stop, deceased. On the date of incident, according to PW1, comma, he had informed by the accused number 1 through the mobile, through the phone, mobile phone, that his mother, the deceased, was assaulted and was lying on the road. Full stop. Accordingly,
Authorized, he says, my mother has fallen on 15/6/2000. Abdul Hamid called me on the phone, informed me that my mother has fallen in the Hakim Chowk, asked me to go and see her. He further told that
was lying on the road.
Yes.
Assaulted on the bed. Was lying on the road and informed him to
go and see.
yes, visit the
And he was in Belgaum. He
Go
says
and,
further he
inform
told
him
that
to
he was in Belgaum.
go and to see the go see her. Full stop. As such, immediately in turn he informed the same to PW6, who rushed to the spot and saw the deceased. She succumbed there only, la?
Yes, my lord. She was taken in the ambulance to the
Yes,
hospital.
Injured. Though she was shifted to hospital, she succumbed due to the injuries. Full stop. Injuries. The PW6 also deposed similarly that after the incident, he came to know about the incident through PW1 and through PW1. In such circumstance, the evidence of PW1 and 6, has to be treated as has to be considered that they are the hearsay witness to the incident. Full stop. Though they deposed in respect of motive for the incident, However, in the evidence in the cross-examination of PW6, it is clearly stated that in the year 2011 itself, the accused divorced the accused number 1 divorced the deceased. Divorced the deceased. Full stop. Deceased. Full stop. Further, the prosecution but relied on the evidence of PW5 and PW7 were the eyewitness to the incident. Among them, on perusal of the evidence of PW5, 5 was with the company of deceased on the date of incident, categorically stated before the court that some unknown persons assaulted the deceased, and due to the same, she sustained injuries on her head and fell on the road. Thereafter, she was shifted to hospital and succumbed to the injuries. Hence, it is clear that she was not able to identify the assailants at the spot on the date of incident. Further, however, though PW7 claimed to be an eyewitness to the incident, though PW7 projected to be an eyewitness to the incident by the prosecution, on careful perusal of the evidence of PW7, at the outset, his statement was recorded by the police after 3 days from the date of incident, that is on 18/6/2013. Full stop. Though he has stated in his evidence that he had seen the incident, he had witnessed the incident by assaulting accused number 2 and 3 to the deceased with the MO12 with the MO1
No, 9 notes. MO9.
MO9, MO9. However, in the cross-examination 9, while he was proceeding to attend a wedding function. Full stop. However, in the cross-examination, he has stated that himself and
CW 20, Karim.
29.
20, 20.
CW 20.
Karim.
Himself and CW 21 Karim were proceeding
To Adil Shahi Marriage Hall to attend the marriage.
to attend the marriage by walk.
By walk.
By walk.
Yes.
By walk on that day and witnessed the incident. Moreover, full show incident. Nevertheless, he also stated that after the he also stated that he was with the he was the close friend of deceased, close friend of
PW6.
PW6 and met him several times after the incident. In spite of that, he failed to inform the act committed by the accused to him, either to him or to the police for a period of 3 days. For a period of 3 days. 3 days. Full show. On 3 days. Full show. Further, there is a serious discrepancy in the evidence, discrepancy in his evidence compared to his 161 statement. In such circumstance, the PW such circumstance, the evidence of PW7 appears to be doubtful in respect of his presence on the scene of occurrence on the date of at the time of incident. He suddenly he suddenly appears in the spot and thereafter disappears for a period of 3 days. 3 days, and his statement was recorded thereafter. This version of PW7 seems to be the proofs that he was a chance witness to the prosecution, chance witness to the incident, full show. Incident to the incident, full show. The incident. Further incident, full show. Further, though the prosecution further as such, on careful examination of the evidence of PW5 and PW7, the eyewitness to the incident, their version, their evidence cannot be considered for as a gospel truth to prove the charges leveled against the accused, right? Against the accused, full stop. Even full stop. Even otherwise, the learned session judge, while appreciating the evidence on record in the impugned judgment category, judgment, observed that the conduct of PW7 not mentioning of the incident for a period of mentioning of the incident either to PW6 or to the police for a period of 3 days creates a doubt in his version. Full stop. Version. Except these witness, the prosecution has failed to place any other reliable evidence to connect the accused in the alleged crime. Full stop. The prosecution also failed to establish the recovery of MO9, the weapons that were used for the commission of crime by proving the Mahazar Exhibit P4 in accordance with the law within the ambit of section 27 of Indian Evidence Act, as per the law laid down by the Honorable Apex Court in the case of Subramania versus State of Maharashtra, State of Karnataka. State of Karnataka 2023, 2023, I ಹೇಳ್ತೇನೆ madam. 23, full stop. For 23, full stop. Hence, overall perusal of the entire evidence on record, comma, the prosecution has failed to place sufficient evidence to prove the guilt of accused beyond reasonable doubt. Full stop. This next part. This being an appeal against the acquittal, comma, the Honorable Apex Court in the case of H.R. Sundara and others versus State of Karnataka reported in 2023, Volume 9 SCC 581, comma, summarized the principles to exercise the power by the appellate court to interfere in the order of Sessions Court in paragraph number 9 as under full stop. Next. Further, the Honorable Apex Court in the case of Mallappa and others versus State of Karnataka reported in 2024, Volume 3 SCC 544, while summarizing the principles in dealing with the appeal against acquittal in paragraph number 42, held as under. Hence, on careful perusal of the above law laid down by the Honorable Apex Court and the evidence placed by the prosecution in the instant case, comma, we are of the considered view that the prosecution has failed to place sufficient evidence to prove the charges leveled against accused beyond all reasonable doubt. Full stop. In that view of the matter, we decline to interfere in the judgment passed by the Session Court. Accordingly, we answer the point raised above in the negative. Judgment under in the affirmative, and proceed to pass the following order. The criminal appeals filed by the state are being devoid of merits. Judgment and yav.
Yes.
ಹೊಸ ಜಜ್ಮೆಂಟ್ ತರಲ್ವಾ ಎಲ್ಲ ಹಳೆದನ್ನ ಯಾವ್ದು ಇಟ್ಕೊಂಡದನ್ನೇ ತರುದಾ ಪದೇ ಅದನ್ನೇ
ಇಲ್ಲ. Next time I'll see to that. I'll produce the latest. Grateful.
ನೀವೆಲ್ಲ ತರದಿದ್ದು ಮತ್ತೆ ಯಾರು ತರುದೇ ಅವ್ರು ಯಾರು ಮಾಡುದು ಇದನ್ನೆಲ್ಲ ತರುದು?
Yes. Grateful.
First.
Pastor matter, 3 number 12. Emma L. Kulkarni, Amresh Rosa.
What happened?
They prepared affidavit.
So how do we dispose of? Take note of it and
Please notes.
you have instructions
Please.
that if they adhere to the terms of the affidavit.
Please. If they did not notes comply with the affidavit notes, the bank may be given liberty to proceed in accordance with law.
Everything is okay. Sometimes they only feel that the rate of interest doubles, triples. So that is the only grievance. Of course, many people try to take undue advantage. But
But
small
even
people-
in a private banks also, even nationalized banks, there are variation in the imposition of interest. SBI is different, my lords, and ICICI Bank is different, HDFC is different. And these cooperative banks also different. When we compare, my lords, cooperative banks were higher rate of interest than other banks.
What is the outstanding from this? What is the outstanding amount?
43 lakhs.
Huh?
43 lakhs. And
What is the principal amount?
40 lakhs.
How much he has paid?
It's as
He
a-
has only he has defaulted 3 installments. He has been September,
No.
from September he is a defaulter.
It's not about interest, my lords. It's a overdraft loan. They're given 1 year time. Within 1 year, my lords, 40 lakhs is credited to his account. Whenever he wants, he can withdraw it. Only on withdrawal amount, my lords, they charge interest. So after 1 year, my lords, he needs to renew it. If he did not renew it, my lords, it's as a, we treat it as a NPA and he becomes a defaulter.
That was NPA, it has
But
become
money,
NPA.
whether they utilize or not, will be considered to be a loan.
Loan.
Overdraft
In the instant case, all 40 lakhs was utilized in a given time by the
utilized,
police.
and then they have not repaid.
No.
The present appeal is filed as an order of the learned single judge, who has rejected the writ petition filed by the petitioner. Reserving liberty to the petitioner to avail of alternative efficacious remedy. At the time of hearing of the appeal, the petitioner, who is the loanee, has offered to settle the dues of the bank and has filed an affidavit, which reads as hereunder. Para 2 to 4. Relevant portion of the affidavit reads as hereunder. Noticing that essentially the dispute of the petitioner is as regards to dues to the respondent bank. And in light of the undertaking made, the counsel for the respondent was asked to obtain necessary instructions. So it's submitted by learned counsel appearing with the respondent bank upon instructions that if the affidavit is adhered to, they would not precipitate matters, and that court may dispose of the matter recording the undertaking, and the event of any default, the bank may be reserved liberty to proceed in accordance with law.
Please.
In light of the said stand of the respondent, the undertaking of the respondent at para 2 to 4 is taken note of, and it is observed that the petitioner is to strictly adhere to such terms as undertaken. In the event there is no adherence to the undertaking in terms of the time schedule prescribed in the undertaking as found in para 1 to 4 of the affidavit, respondent bank is at liberty to proceed to enforce their rights as regards the dues in accordance with law. Accordingly, appeal is dismissed.
My lords may kindly observe that meanwhile they shall not precipitate, my lords.
Needless to state, till the lapse
30th
of
April
the
end.
time period
Mentioned.
mentioned at para 3.
3.
The respondent bank are to keep in abeyance all, are not to precipitate the matter.
Please.
Great.
Please ask him that there is no escape.
I have asked.
No,
He is
no.
ready to.
I'm saying there is no escape.
Escape.
No. Normally what happens?
Only when we admit the liability, I am before High Court. Otherwise, I'll send them to
No,
the
no, correct.
proper forum.
I'm saying, so only way to get rid of it is to buy peace by,
Yes. That's true.
because they won't leave.
Yes.
They won't leave.
It's like Vikram Betal
Ah, those who leave have left.
have left.
Those who
Yes.
have left.
Gone.
Hmm.
Have left the abode.
Actually,
Parties
bankers, my lords,
presence may be
they,
limited means.
they credit the installment, whatever borrower pays, they credit into the interest, my lords, first instance. That is the reason, my lords, it
Principal
multiply the.
remains. Yes.
May I request the presence of the parties before this court?
Ah. Order sheet and sign. The
Grateful.
appellant is present in person and affirms to the undertaking the affidavit.
DG Chagashetti.
Lord, in this matter, my lord,
We'll have it on Monday. Let him have a look at it. We'll have it on Monday or Tuesday. Monday.
please, on Monday, Lord.
Monday.
Because, my lord, he has not made the Tahsildar as party, my lord. For that is the reason, my lord, I want to bring to lordship notice, my lord. Here, my lord, ADL is, he made the party ADLR, but ADL has filed the, my lord, report and affidavit before lordship. But direction, there is no direction to the deputy, the Tahsildar. But he made the application to the Tahsildar for taking action against the private party who is, my lord, interfering with the possession of the land. But civil court is that is the observation by the learned single judge, but he has to approach to the civil judge. But my lord, here, my lord, there is a direction, my lord, to the ADLR. ADLR nothing to do. Even though, but he filed the my lord affidavit along with the sketch and all everything. My lord.
Let us see. Monday.
Please, my lord, Monday.
For 36.
Ah.
I pay for the respondent.
Ah.
Appeal against acquittal. May I request Monday or Tuesday, my lords?
36,
my lord.
Ah.
Appeal against acquittal by the state. Sorry.
You seem to be in a hurry. Acquittal, against acquittal.
Yes.
You are on the other side.
Yes, I am for the respondent accused. 36.
You appear to be in a hurry.
No,
Huh?
not in hurry.
No.
Yes.
Sometimes lawyers hear the whispers under the earth.
Well, it's afternoon.
Huh? No, bench.
Please.
What about tomorrow, SPP? One appeal we can dispose it tomorrow. One appeal, which appeal?
Tomorrow, my lord.
Ah.
Tomorrow.
Yes,
Yes.
Rajesh.
Yes.
Tomorrow, 37 of them.
Please.
Also 39 matter, my lord, sorry.
Huh.
Still 39. If my lord, a date is given,
Put it.
first week any date, sir.
Put it.
Much.
Thank you. यार MFN
Court officer, court officer, court all mic mute ಅದ ನೋಡ್ರಿ. ಹೇಳಿ ಸರ್. ಎಸ್ ಸರ್.
ಧಾರವಾಡ ಟೋಟಲ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಇತ್ತು.
very well, no?
Yes.
आवाज बराबर नहीं आ रही राजा, और करो। Very good.
Yes, brother.
Yes. Yes.
We can't hear you, counsel.
What is it first? Is it first matter, Lords?
Yes, yes.
I appeal for the petitioner. So, petition filed.
No, we are in RP 217 of 2023.
That is a principal bench matter. Principal bench matter. Mr. Gupta.
Yes, Your Honor. I'm here.
We'll hear this matter in physical because
Even party in person is not there, sir. Have you served the copies, Mr. Gupta?
Yes, Your Lordship, I sent them the paper of as direction, the entire memorandum.
It is not acknowledgement is not filed.
I sent it.
Acknowledgement is not filed. Acknowledgement is not filed. Huh?
Long back I have sent it to her.
Where is the acknowledgement?
About 4 weeks earlier.
Acknowledgement for having sent the papers.
Is with me, sir, Your Lord.
Huh?
As per the card list, now I have not produced before the court. That is the thing.
Please produce that. Please produce that. Please produce that.
She is not denying, Your Lordship. She has received it.
Yes, we will grant some time.
Send the acknowledgement also.
Madam is also not there. Your opponent party in person is not there.
Your Lordship is left to you. You know very well. We are more than 16 years now. I have everything prepared. Your own judgment by your own bench, Your Lordship. 12 years been held sufficient.
All right, let her come.
More than sufficient drivers. I am ready with all my submissions, Your Lordship. I can pit. I will make written. I can submit if you permit it.
No, she is not there, sir. Party in person is not there.
I cannot help, Your Lordship. I am no one. It is her duty to be before this court.
We will give one opportunity. Yes, Barkul.
My party is suffering like anything, Your Lordship.
Yes, we'll consider that.
And he is unemployed. Both were employee at that time. Both were working class at that time, Your Lordship.
All right, you file this acknowledgement for having served the copy.
See, Your Lordship.
Learned counsel.
If she refuses, I can produce that one. When she is accepting it, is no problem. It's only a technical point, Your Lordship.
Please file that technical. This the acknowledgement also. Please file that.
However, now I can file it. That will take it. That is not a problem. But
yes.
Your Lordship may appreciate. It should not be a technical reason for not to be heard to me.
No, she should be there. No, without her absence. Otherwise, another review to review. One opportunity we should give to her. No.
My submission, Your Lordship.
We'll notify her. We'll notify her with the date.
We will notify her a date of appearance. We send a notice once again. If she does not come, we will consider.
Your Lordship, as I am at your disposal. Whatever Your Lordship decides.
Yes, Barkuri. Yes. Now you listen to the order, sir. Yes. Learned counsel for the appellant submits that all the copies of the review petition are served on the respondent party in person, and he would produce the acknowledgement for having served the same. Said submission is placed on record. He is permitted to do so within a period of 1 week. There is no representation for the party in person. Respondent party in person is not present. To provide one more opportunity, list on 2 weeks.
Your
2 weeks only, that's good. 14th. 14th, Friday. Sir, 14th February. 21st February 2025. Registry shall communicate the date of hearing of the present proceedings to the
Your
respondent
Lordship,
by way of.
I will
Yes.
file it. I will
Yes,
file
please.
it. What I've done, I will again send it another notice also. No problem.
Please,
But
please, do that.
my prayer is, Your Lordship, my prayer is, it should maybe a bit earlier possible, because lot of suffering.
No, notice has to go to her and come back from the court.
He is also unemployed, Your Lordship, now last 8 months. And aging, if they want to marry, Your Lordship have to appreciate that.
We'll consider that. We'll consider that. Yes.
Earlier date may be given, Your Lordship. If possible, earlier
Because
date.
notice has to go and come back to her place. Now we are director registered to send notice for her appearance. If she does not come, we will hear you on next date of hearing.
No, the court notice going, Your Lordship, to her?
Now court notice indicating, because she is a party in person, court notice has to go. She is not present. How will she will be knowing next date of hearing? That is the reason we have issued notice to her. Yes, next case.
Mohammed Tahir.
Lordship, appearing for the petitioner, Lordship, in this matter, Lordship.
State.
State is, Lordship. Last occasion also they have sent, Lordship. Lordship, kindly appreciate this petitioners are in judicial custody, and the review I filed in August 2023. May I make one request with due respect, Lordship?
This is on legal contention, nothing to do with their detention as such. No.
Lord, detention, Lordship, maybe a legal contention, but there's in respect of the wrong jurisdiction, Lordship.
They are not there. We will see that what is to be done. Just we wanted to know. I also just discussed with His Lordship. This notification, what is called out here, is issued by the state government. No. Whether state has a power to issue notification other than 22.
No, Lordship, that is a government order. It's not a notification. Government order to appointment infrastructure, Lordship.
Okay.
That is nothing but
distinction you wanted. Now state is not there. What is to be done now?
Lordship, with due respect, may I make one submission, Lordship?
Yes.
Lordship, Lordship is sitting with another roster in principal bench with the habeas corpus. And so review is because of the review has been getting delayed because of the non-availability of the both the judges.
No, not like that. The availability both are here only.
No,
virtually there is no issue for that. It is not that non-availability. State has took
Lordship,
time. They have filed objection.
Regularly, Lordship is not sitting over that period. They already filed, Lordship. Everything has done. Objection is already filed. It's on record.
No. Last time,
more than 1 year before.
Please recollect. Your colleague was there. They wanted to produce the original records of this notification, so that ourselves wanted to satisfy.
Last occasion, this was 3 days before, Lordship. Last occasion, they come out with another habeas corpus petition, and they were reading out.
Mr. Tahir, now you have challenged the order passed in habeas corpus has been rejected, isn't it?
Yes, Lordship. Yes.
So now we are only in review. So it's not. It cannot be considered as if it was a habeas corpus. Now the point you have raised is a notification. That is an internal procedure. Even otherwise, how are you prejudiced by it? Now, if under 11 or 22, either the state government or the central government can give a notification.
Yes, Lord.
Once the notification is issued, whether they are entrusted by way of assignment of an executive order or not, are internal procedures. How are you prejudiced by it?
This is the wrong jurisdiction, because our contention is that where the case is pending, it is appointed under section 11. The appropriate court is it is a deemed session court of Mangalore district. For that reason, all these difficulties are there, Lordship.
No,
one,
correct.
another.
There is no inherent lack of jurisdiction by the sessions judge.
Yes, Lordship, inherent lack of jurisdiction, Lordship, this is.
On what ground? Who has
On
tried
ground
it?
that this,
Who's
the
trying-
court
Who is trying it? Who is trying it now?
is trying the court appointed under section 11.
No, who is it? A sessions judge?
Session judge is appointed.
How are you saying a session? Now let us, for a moment, just ignore the notification. Is a sessions judge not competent to try this offense?
Lordship, the jurisdiction, because of the territorial jurisdiction I'm talking about, not in the respect of the rank. Rank may be the proper, but territorial jurisdiction is wrong, Lordship.
All that is a technical contention which we'll hear. But
Mohammed Tahir, I'll tell you, we just discussed with his Lordship morning after seeing this file. We wanted to ensure that whatever raised the contention, valid contention, we confer from the records and pass the orders. You want that, otherwise you want to argue, we'll consider and pass the orders. You want to argue, make some
I will argue, Lordship.
No.
Every date I always ready.
No, we thought we'll give an opportunity for them and secure the records. But you still
I just
wanted to argue,
early
please
disposal.
argue. We have no objection. We don't
Lordship,
want to.
I just want early disposal. If Lordship will permit me, I'll argue.
No, it's always open. You want to argue, we'll consider and pass the orders.
Now, what do you say regarding the order passed by the coordinate bench, which has considered the same contention?
No, Lordship.
In the
Kindly
case
take
of
this.
WPHC,
Take this order, Lordship. This order is there in my hand, Lordship.
No, 52 of 2024. What do you say regarding that order?
Yes, Lordship. Kindly take the para number 11, Lordship. Page number 10. The contention raised in this case, habeas corpus, is that habeas corpus is not maintainable because the petitioner in this particular case were in bail. On that ground, this habeas corpus will not be entertained, Lordship. Kindly take para number 10.
Para 12 gives a finding on that.
Yes, Lordship.
Para 12 gives a finding on that contention.
Yeah, Lordship. I'll read this para 12 as well, Lordship. I'll start with para number 11 and I'll read the para number 12 as well, Lordship. In the instant case,
yes.
Is the instant case the petitioner is on bail in so and so number, the same is not disputed by the learned counsel petitioner. In order to invoke writ of habeas corpus, a person must be in actual detention or imprisonment, and such action must be illegal or unconstitutional. If a person is not actually detained, obviously writ of habeas corpus would not lie. Hence, we find substantial force in the plea of the learned SPP. The grievance of the petitioner in respect of the cognizance order passed by the wrong forum court, which is not eligibly designated by the trial to case under NI Act. The only remedy available to the petitioner to oppose the central or state government as contained in section 11.1 and 11.2 of the NI Act, the same cannot be challenged by the filing of writ of habeas corpus. Hence, the said contention of learned counsel for the petitioner in this regard is also liable to be rejected. The judgment relied by the learned counsel is not applicable to the facts and circumstances of the case. Hence, the detail or discussion is not required in the same. In such circumstances, suffice to hold that the petition is not maintainable and the same is liable to be dismissed. So it will dismiss on the ground of maintainability, not on the findings, Lordship. Now, Lordship, kindly take the
How can you say that? What does para 12 say? It is rejected.
12 says that, Lordship, the finding was given that
para 12
same cannot be challenged in way of habeas corpus. But by the petition which I am challenging in review, their specific contention was been discussed, issue was framed, and the court has held that is already relying on the Supreme Court judgment. Court has held that habeas corpus review is maintainable. For that reason, I am pointing out the impinging order which is before this honorable court.
No, we are not saying habeas corpus is not maintainable. Who said habeas corpus is not maintainable?
No, this judgment is passed on that ground, Lordship. And in this case, which is before this honorable court, the petitioners are in judicial custody. In this case, they were in the bail. For that ground, on that ground, this particular petition was disposed on this ground. Now, Lordship, kindly just take the judgment.
No, we don't agree with you. It's not disposed only on that ground. Para 12 is a finding on merits.
Lordship, kindly take section 11, which finding, on which basis.
Let us see, unless the state takes its stand, we can't pass an order which has implication throughout the state.
No, Lordship, for that reason, I am making a request. Lord, kindly just find a way to dispose it off. I am not insisting for today disposal, Lordship. My humble submission is that they are in judicial custody. That has to be considered. That's it.
Who appears for the state?
Mr. SPP1 is appearing for Mr. Bilappa last occasion. And even last to last date, specific notice was issued from the court to appear on each date. In spite of they are not appearing. Lordship, they are not bringing the facts before the court. They are always taking the time.
Who appears now? Who appeared last time?
SPP Mr. Bilappa has appeared, Lordship. SPP1.
Beliappa, is it?
Yes.
We'll telephonically contact him. We'll pass over. Phone ಮಾಡಿ Beliappa.
Just pass over.
Lordship, I'm extremely sorry for agitation, but Lordship,
No,
kindly.
no.
That's okay.
No, no.
That's okay.
Who else wanted to see the records and pass the orders? It is not that hurriedly. You raise some contention. We need to answer that. We'll see
Please,
that and we'll do it. Wait. Yes. Yes. Hmm. What is that application?
Application to amend, my lord, the name of the respond, this is respond number 9.
Appellant.
So he is one of the respond number 9.
In appeal. Sukhdeva. What is his name?
Is Sahadeva. His name is Sahadeva. It's wrongly mentioned as Sukhdeva in the writ appeal. So it has to be corrected as Sahadeva.
What application you filed?
Plus the application to amend, my lord, his name.
Where is that application?
Plus, that's IA 1 of 24.
IA 1 of 24. Now, no, anybody is appearing for him?
But sir, my lord, he's expired and his LRs are served unrepresented. Notice are issued on his LRs.
Recording. Orders on IA 1 of 20. Sir, he says that there is some typography error in the name.
Yes.
I'll dictate here only, sir.
Yes.
Learned counsel for the appellant submits that by inadvertence, the respond number 9 is named as Deva K instead of Sahadeva. Sahadev K. To stop. A notice issued to the legal heirs of respond number 9. Those heard, they are not appeared. Hence, the application for amendment is allowed. The appellant is permitted to amend the cost title within a period of 1 week. Yes, next.
Yes, the IA 2 of 24 is, my lord, to appoint the guardian, the LRs of the respond number 9.
They are minors, huh?
Please, my lord, 2 of them are minors, my lord. That is the respond number 9, 9B and D.
What is it, IA?
IA 2 of 24. 9B2.
Shishikala N.
She is the mother.
She is there on record?
She is there on record. She is available, but some of them are referred. She was not there on record earlier. Now she has to be brought on.
For that also you need to application, no? This is application, no?
Please, my lord.
Recording. Orders on. This can be allowed, no? Yes. Heard on. By 2 of 24. Orders on so heard. Peruse the averments made in the affidavit accompanying the application. It is pleaded that the respond number 9 has died and the legal heirs of the respond number 9 were brought on record. And the
to be brought on. And that application is also pending.
To be brought on record. And they are the minors. Considering the same, Srimati Shashikala N, wife of respond number 9 and mother of the minors, are appointed as a natural guardian, as a next friend to represent 9, proposed 9B to D. Correct?
Please.
Accordingly, I is allowed. The appellant shall amend the cost title. Now, notice it is heard on that. What is that IA?
That IA is more, the LR application is 5 of 24. That LR application, bring them on record is 5 of 24.
What is that?
That's a bring the legal representative respondent number 9.
Really? 5 of 24, huh?
Fixed, LR legal representative application. There is a delay, my lord, that is 3 of 24. The appointment is 4 of 24. 3 of 24 is a delay application.
Orders on IA 3 to 5 of 24. Third, peruse the averments made in the affidavit accompanying the application. The records indicate that the Sudev, respond number 9 has died on 20th 10/2021, and respond number 9A2, they are the legal heirs of the deceased. The said application is duly served, no representation for the legal representatives, hence the application is allowed. The delay of so and so days in filing the application is condoned. Abatement is set aside. The legal heirs of the respond number 9A2, what is B2? B2D, A2D are permitted to be brought on record. The appellant shall amend the cause title and file amended cause title. Yes. ಅಷ್ಟೇನಾ? ಏನ್ petition ಆಮೇಲೆ ನೋಡೋಣ. Rest after 2 weeks. Yes. ಆಯ್ತಾ?
Harvard bench, serial number 1, Ravi S. Balikar.
Lord, I additional notes. I pray for a short accommodation next week on the embarrassing position. In the court hall, Lord, I lost my file in the morning. I'm in a panicky position. I had made notes in the library and kept it. Somebody has taken it. I'm just frantically searching. Otherwise, I'll rebuild it by 1 week.
We'll have it, I think both of us will sit together and hear it. We'll have it after we come back.
Very well, that can be done. That can be done. The only point that I'm canvassing is my interpretation of section 15, bona fide requirement. Matter was taken to Apex Court. The matter is disposed of, permitting us to file a review notice. Hence, I am before the lordships.
May not be disposed of, dismissed, I think.
Dismissed and Lords, I also went through it. Lords, because the direction, I am before your lordships.
List after, at request made on behalf of the counsel for the petitioner, list the matter after 4 weeks.
Obliged.
Serial number 2, government advocate.
Lords, I appear, Lords. Lords, as per last date of submission, Lords, I have filed a memo withdrawing, Lords, the ground search in para number 12, Lords. I am extremely sorry, Lords.
You filed a memo for withdrawal.
Please, withdrawal of Lords, ground number 12, Lords.
Ground number 12. When have you filed the memo?
Please, Lords, I.
7/12/24.
Filed on 9th of December, Lords.
Lord's kind permission.
Just 1 minute, just wait.
Yes.
It is dated 7/12.
Dated 7/12 minutes.
Ide.
In the registry filed on 9 minutes.
That may be expunged, that one, that
Yes.
ground.
Learned AGA or SCGP?
AGA minutes.
Learned AGA, Sri Praveen Uppar. States that by inadvertence, ground number 12 is taken in the review petition, and he may be permitted to withdraw the same. In view of the said submission and specific memo to that effect. Ground number 12 is expunged from the review petition. Yes.
So only contention is that, Lords, on the date of hearing of writ appeal, Lords, the document, Lords, which I supposed to produce, that lease deed, Lords, entered into between the corporation and one Mr. Nargundkar, Lords, was not available. Therefore, Lords, we made a submission that, Lords, the corporation was writing, Lords, passing a resolution, Lords. So now, Lords, we the property to one Nargundkar, and in turn he, Lords, sold it to the father of the Lords, petitioner in writ petition. That is
No,
respondent.
that your contention is considered by the single judge and rejected. You don't want to seek review of that, and you are seeking review of the division bench order.
Now, Lords, after passing of time, Lords, the writ appeal order was also passed. Therefore, Lords, we are in writ appeal, Lords, our submission was contrary to petition, Lords. Therefore,
Lords, the
If my lords permit me, I would submit.
Another ground, my lords, what my learned friend wanted to say is that, my lords, the corporation, my lords, being aggrieved by the order of this writ appeal, my lords, approached Honorable Apex Court. And now, my lords, on the last date of occasion, I learned that, my lords, the Apex Court also dismissed the SLP on the ground of delay. My lords.
Where is that order? SLP order?
That was not, my lords, last Wednesday, my lords, the
Where
contempt
is
was
Mr.
listed.
Srivastava?
No, that is at diary number 47376 of 2024. The Supreme Court was pleased to dismiss it on the ground of delay. That is admitted by the municipal corporation. Now, what happens is, my lord, this state government never raised any murmur of protest, either before the learned single judge or before this honorable court. Now, all the time it has been firing the salvo from the shoulders of the corporation. Now wants to file a review. No objections filed in the before the learned single judge. No review of learned single judge's order. And after the Supreme Court took note of the delay of corporation, my lord, now delay of state government cannot be considered favorably.
Here also delay.
284 days of delay, my lord.
They are not issued notice also, no? On this.
No, my lords. Day before yesterday, contempt was listed, and my lords, there was an order to, my lords, serve a
Contempt has
copy.
been
Today, I
pending
have
since the
served a
last
copy.
7 months.
What was the order in the contempt proceedings?
Lords, they were directed to execute a registered sale deed in favor of this respondent in terms of the orders passed by the learned single judge.
Comply there. They are not.
No, we'll dispose it in the presence of the council for the
My
corporation,
lords, may
city corporation, unless you are going to give it up voluntarily. Yes,
I'm sorry, my lords. A little bit, my lord, disturbance due to, my lords.
No, we are
there is-
saying then let the now let the commissioner for corporation come. We'll see. Anyhow, we have not. There's no stay of the order. Contempt is going on. Let the commissioner for corporation come. We'll see. You serve the council for
Please,
the.
please.
We'll make it clear, however, that there is no restraint on the order. We are only going to notify him and then see.
Please.
Lord, there was an attempt by the state to wriggle out of the situation, saying that the
Let us
order
see.
was vague. And this
No, let
honorable court was pleased to clarify, saying that the state carries the same responsibility as that of the corporation commissioner. And had
Anyhow-
also directed the revenue secretary to remain present. And it is at that time that the review came to be filed and the SLP was also preferred.
Let us see. While making it clear that there's no order of the court is not staying the order passed in the present proceedings, copy of the review petition to be served on counsel who appeared for the
Parties.
Second
City
respondent.
Corporation Belgavi, as well as the private respondent in the writ proceedings.
Yes.
We'll fix a
Please.
date later.
Obliged.
What is there? Speed always for money. Age of money.
May I make one submission? Even I filed an RTI before the Registrar of High Court to ascertain that any application is moved by the state court regarding appointment of under Section 22, and I received the order reply also. No application is moved. Even the RTI reply also I placed before this honorable court.
No, is there? We'll hear it in the presence of the state council. It's too important a matter to be heard either without the presence of the state.
But I'm not insisting dispose today. I just wanted to dispose it as early as possible, Lordship. That's it.
Let us see, but no, the state public prosecutor to ensure appearance with instructions copy of the order to be sent to the state public prosecutor in light of the special bench is required to be constituted for hearing. Matter is adjourned. Date would be fixed.
Lordship, one more submission, Lordship.
Yes.
Even the records of 97/2022 orders also may be summoned, Lordship, if anything is there.
Oh, they will bring
19/7.
19?
19/7/2012.
The
The government
record-
order, which I am.
Yes, yes, 19/7.
The state to place before the court necessary records.
Yes.
Which would have a bearing on the adjudication of the present dispute. Yes.
Yes.
Request for the short date, Lordship.
Let us see. We have to sit together. At least we have to whisper to each other. Now, see, it's only a review, so we'll take it up. But it's a legal question which we cannot do
Yes, Lordship.
without.
For that reason, because this issue, what is happening is all the cases from all over the states are getting transferred in the court. Only one court in Bangalore. This has to be decided, Lordship. It has a very severe repercussion in all so many matters, Lordship.
Let us see. If possible, we want to sit together because it may require some consultation inter se amongst us. Because it's a legal question, even if it takes time, let it be settled once and for all.
Obliged.
ನೀವು ಬಂದಿದ್ದು ಒಳ್ಳೇದಾಯ್ತು. ನಾನು ಅನ್ಕೊಂಡೆ ಮೇಡಮ್ ಯಾಕೆ ಏನಾದ್ರು ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಮೇಲೆ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿ
ಬೆಳಿಗ್ಗೆನೆ ಒಂದ್ ಮಂಗಳಾರತಿ ಆಗೋಗಿದೆ ಅಲ್ಲಿ.